What is a will? You have a caudal definition in Article 783. A will is an act whereby a person is permitted with the formalities prescribed by law to control to a certain extent the disposition of his estate to take effect after his death. From Article 783 and the following articles, we can deduce certain fundamental characteristics of a will. One is that it is a strictly personal act. This is one thing which each one of us would have to do personally. We cannot delegate the making of a will to our best friend, not even through an express special power of attorney. It cannot be accomplished through the instrumentality of an agent or attorney. Hindi pwedeng yung mayaman na testator sabihin, tawagan ng abogado, attorney, gawa mo ako ng will, o ano hong lalagyan natin dito? Ay, bahala ka na. Mas magaling ka naman sa akin. Hindi pwede yun. The testamentary disposition should come from the testator himself. The testator, as a matter of fact, is even prohibited from making testamentary dispositions whose validity or compliance will depend upon the will of another person. I call your attention to Article 787, for example. The testator may not make a testamentary disposition in such way that another person will have the power to determine whether it shall be operative or not. I cannot say, for example, in my last will and testament, I hereby give my house and lot or my farm in Bulacan to my brother B, provided my wife will agree. Hindi pwede. Okay? Prohibited by Article 787. Okay. The testamentary dispositions must come, and the disposition of the property must be decided upon by the testator himself. Having said that, you take note of the provisions of Article 786. However, so we're still talking of yung, sabi natin, the disposition of the properties must be decided upon by the testator himself. Under Article 786, the testator is permitted by the law to give a specific property or sums of money to a class or a cause. Specific property or sums of money, he can give that in general to a specified class or cause. And under the same provision, he is allowed to delegate the actual distribution to a third person. Pwede sabihin ko sa aking will, I leave the amount of 100 million pesos, okay, for the street children of Metro Manila. Okay, 100 million. So, let's just assume that I have 100 million. So, if I have 100 million, sufficiente, the legitimes of my compulsories will not be impaired, then the 100 million will be given to the street children of Metro Manila. I can say in my will, I leave the distribution of that amount to my executor. So, yung executor ko na, magdidetermine, o sino ba yung mga street children, siya na mag-distribute nun. That's permitted. But I cannot give my executor a blanket authority or a blank check. I cannot say, I authorize my executor to get from my estate as much as he may deem necessary and to distribute it to the street children. Hindi pwede yun. It must be specific property or sums of money. Okay? All right. The moment, however, the testator refers by name, pinangalanan niya. The moment he refers by name to the testamentary beneficiaries, forget about 786. One step backward, you apply 785. Okay? And under Article 785, the duration or efficacy of the designation of heirs, legacies, or devises, or the determination of the portions which they have to take, when referred to by name, cannot be delegated to a third person. Tandaan lang natin, in Article 786, the beneficiaries are a specified cause or class. In 785, the beneficiaries are a specific named institutions or individuals. So, I cannot say in my will, I hereby bequeath the amount of 100 million pesos to Centro Escolar University, San Sebastian College, and University of Santo Tomas. And I leave it to my executor to determine how much out of the 100 million will be given to each of these institutions. Hindi pwede yun. Because I have referred by name to the beneficiaries, I am not allowed by Article 785 to leave to the discretion of a third person the duration or the efficacy of the designation or the determination of the portions which the named beneficiaries will get. Okay? 785. Next point. No matter how carefully a will may have been crafted, no matter how experienced the lawyer who drafted the will may be, there is always the possibility of an ambiguity in a will. There are two general types of ambiguity: the patent ambiguity and the latent ambiguity. Patent ambiguity is an ambiguity which is obvious, apparent from a mere reading of the testamentary provision. I give to 2 of my 5 brothers my house and lot in Quezon City. Oh, basa mo pa lang noon, alam mong malabo yan. Sino yun? Because the provision itself says he is giving the house and lot in Quezon City to 2 of his 5 brothers. But he did not even bother to name who these 2 brothers are. Okay. Pwede bang you apply the shotgun method? You give the property to all 5 brothers at siguradong tatamaan yung intended beneficiaries? The answer is no. Why? Because whatever happens, the principal rule in testamentary succession is always the ascertainment of the intention of the testator. That is the guiding star in testamentary succession. And obviously, in that case, the testator did not intend to give that property to all 5 brothers. He intended to give it to only 2 of them. That's a case of patent or obvious ambiguity. What is the solution? Intrinsic evidence as well as extrinsic evidence, but excluding the oral declarations of the testator. Okay. Ano yung intrinsic evidence? Evidence found in the will itself. You read the other provisions of the will. For all you know, in another page of the will, baka may nakalagay doon, to my 2 brothers, Procopio and Tarpulano, I want you to take good care of my house and lot, which I am giving to you. Okay? I want my other relatives to know that the reason why I gave these 2 brothers that property of mine is because they were the ones who helped me a lot when I was still running for public office. Okay? They were able to mobilize voters for me. Ayan, solved. Intrinsic evidence. Evidence found in the will itself. Extrinsic evidence, pwede yan. But excluding the oral declarations of the testator. Hindi pwedeng during the contest as to the meaning of sino ba yung 2 brothers na yan eh. All 5 brothers will be presenting witnesses. Okay? Tigi-100 testigo sila. Brother number 1, 100 witnesses. Eh, nadinigo namin yung testator during his last birthday na itong brother na ito ang sinasabi niya na binigyan niya ng property. The next brother will present another 100 witnesses. Eh, sabi nung testator nung nakausap namin eh, ganito, ganyan. In other words, hindi pwede ang sabi-sabi. Okay? Basically, hearsay. And fundamentally dangerous and risky. Because as I always want to emphasize, at that point, the testator will be 6 feet below the ground. Okay? He's in no position to object. He's in no position to belie the false assertions of lying witnesses. Death would have permanently sealed his lips. Sabi nga. So the law very wisely says, hindi pwede yung mga oral declarations. If it is not an oral declaration, alam mo, may sulat, pwede yan. My dear brothers, Tarpulano and Procopio, I want you to know that today I made my last will and testament. And in that will, I gave you my house and lot. Okay? Pwede yan. Alright. What about latent ambiguity? Ito yung ambiguity which is not obvious. Okay? Obvious ba? Sabihin. Kung obvious, patent. Pero kung hindi obvious, latent. Okay. Sabi ng testator, I give my first cousin, Jose Santos, my house and lot in Quezon City. Oh. Reading that provision, is it clear or not? But it's as clear as morning sunshine. Okay? He's giving his house and lot in Quezon City to his first cousin, Jose Santos. Paano kung after the death, 5 pala ang first cousin niya na pare-parehong pangalan, Jose Santos, which is not an outright impossibility. So, what now? Same solution. Intrinsic evidence, you read the other provisions, baka merong ibang provision doon which will clarify the ambiguity, or you may have to resort to extrinsic evidence. But then again, excluding the oral declarations of the testator. You give the words of a will their ordinary grammatical sense. Technical words, you give them their technical sense. Unless it is clear that the will was prepared by the testator all by his lonesome self and that he used certain technical words without realizing the technical meaning of those technical words. General rule, as I mentioned a while ago, testacy is to be preferred over intestacy. If there are two ways of interpreting a will, one will result in intestacy, you avoid that interpretation. You always try to have testacy. One last point. The validity of a will as to its form depends upon the law in force at the time of execution. If there are subsequent changes in the law, they will generally not affect the validity of the will. Okay? Exception. If the subsequent law provides for retroactivity. Exception to the exception, even if the subsequent law provides for retroactivity, if in the meantime, prior to the effectivity of the new law, the testator has died. Why? Because in that case, we go back to our favorite article, 777. Upon the death of the testator, successional rights would have been transmitted. These are already in the nature of vested rights. They cannot be impaired by a subsequent change in the law, even if the subsequent law provides for retroactivity. Okay? We are now ready to talk about testamentary capacity and intent. Remember the basic requirements before a person can make a valid will. Okay? At least 18 years of age. The testator must have already celebrated his 18th birthday or the 18th anniversary of his birth. If a will is made by a testator, let's say 2 days before his 18th birthday or a week before his 18th birthday, that's not a valid will. And of course, must be of sound mind. Okay, soundness of mind. You better remember the caudal definition of soundness of mind under Article 799. Okay, especially paragraph 2. To be of sound mind, all that the law requires. The testator, at the time he makes his will, should know the nature of the estate to be disposed of. He should know the proper objects of his bounty, and he should know the character of the testamentary act. As long as the testator knows all of these three, at least in a general way, then he has testamentary capacity. The law is even more categorical. If you look at paragraph 1, okay, it is not required that the mind of the testator be wholly uninjured or unimpaired by disease or any other cause. In other words, kahit na may konting topak, pwede pa rin. Can still make a valid will. As long as he satisfies the minimum requirements under paragraph 2 of Article 799. He must know the nature of the estate to be disposed of. This simply means that the testator must know in a general way at least what are his properties. Okay? He may remember that he has, a house and lot somewhere in Quezon City. Even if he cannot remember the exact address, that will be sufficient. He remembers that he has a substantial deposit with a certain bank. He may not remember the exact amount, but as long as he knows it's quite substantial, it's in the millions, that should be considered sufficient. He knows he owns valuable paintings by both local and foreign masters. Meron siyang Van Gogh, merong Rembrandt, may Amorsolo. Okay? He may not remember the exact details about each and every painting, but as long as he knows in a general way that he has these paintings, he has soundness of mind. Of course, the presumption is always of soundness of mind. And that's the reason why I always tell my students we are all very lucky and fortunate because we can always invoke that presumption in our favor. We are all presumed to be of sound mind. Of course, that's a disputable, rebuttable presumption. Of course, under the Civil Code, sometimes the presumption is reversed. And when would this be? If the testator 1 month or less, hindi 1 month or more, 1 month or less, before the making of the will was publicly known to be insane, then the presumption is that he was not of sound mind, and he who alleges otherwise would have the burden of proof. Along the same line, if the testator made his will after he has already been placed under guardianship, precisely because of unsoundness of mind, then the presumption is that he did not have soundness of mind at the time of execution. All right. Testator must know the proper objects of his bounty. That's one of the requirements under paragraph 2 of Article 799. This simply means that at the time of the execution of the will, the testator should still know who are the persons closest to him, who are his close relatives, who are the individuals who, by nature of their close relationship to the testator, would have the natural right to expect something from him. Who are the people who in the ordinary course of events would be given properties by him? This would be his closest relatives. If at the time that the testator makes his will, he could not even recognize his own wife, he does not even recognize his own children, which can sometimes happen, then he would no longer be capacitated to make a valid will. He must know the character of the testamentary act. This simply means that he must know that he is making a last will and testament, that it is this document, this will, which will be used as basis for distributing his estate when he dies. He should know that it is within his power as testator to revoke his will any time before his death. Supposing that a person believes in the existence of unseen beings. He's somebody who believes in dwarves, okay, elves. Niniwala siya na may mga duwende. And let's even say he even claims to talk to these creatures. Is he necessarily incapacitated to make a will? I do not think so. Okay? As I always say, I believe in the existence of angels. I believe that each one of us has a guardian angel. I believe in that. That does not mean I'm incapacitated. So mere belief in the existence of these unseen spiritual beings will not necessarily render a person incapacitated to make a will. There is no maximum age for making a will. There is a minimum but not a maximum. So, even if the testator is already 110 years old, okay, sabi nga amoy lupa na, he can still make a valid will. He may be suffering from a host of diseases. Lahat ng klaseng sakit nasa kanya. May pneumonia, may diabetes, may heart condition, may hypertension. Okay? Name it, he has it. That does not incapacitate him to make a valid last will and testament. As long as he is still able to meet the basic requirements under paragraph 2 of Article 799. As long as he knows, in a general way, the nature of the estate to be disposed of, the proper objects of his bounty, and the character of the Testamentary Act. How about drug addicts? Can they make valid wills? Yes. As long as at the time of execution of the will, okay, they still knew the nature of the estate to be disposed of, proper objects of their bounty, the character of the Testamentary Act. The same thing may be said with respect to alcoholics. They can make a valid will as long as they satisfy the basic requirements under Article 799. The capacity to make a will must be possessed at the time of execution. As long as the testator was capacitated at the time of execution to make a valid will, his will is valid, even if he subsequently becomes incapacitated. If Mr. X made a will at the age of 22, and when he made his will, he was of sound mind, but 2 years after the execution of the will, he became insane, and he died in a state of insanity, his will should be allowed. What matters is that when he made the will, he was fully capacitated to make one. Conversely, if at the time of execution, the testator did not have capacity, even if he subsequently acquires capacity, his will remains invalid. If the will was made by a testator at the age of 17, and he died 10 years later at the age of 27, his will is invalid. Because when he made that will, he did not possess the required capacity. We do not have oral wills. All wills must be in writing. Okay? The law does not specify the material to be used. In the case of a holographic will, any material may be used. You may write your holographic will on, of course, a piece of paper. You can write it on the ceiling. Gusto mong gayahin si Michelangelo. You can write it on a wall. You can write it on a whiteboard. Anything. Pwede mo. To use an extreme example, you can even write it sa balat ng pakwan. Yung balat ng pakwan. Lagay mo doon. Everything to so and so. Date, sign. Valid yun. Okay? And I always remember that case which happened in I think it happened in the U.S., where there was a farmer. He was tilling his farm. He was using a tractor. Okay? Perhaps the slope was just too much. The tractor overturned, and the poor farmer was pinned down. Can you imagine how heavy that was? Buong tractor, naipit siya doon. He realized he was dying. What he did was he got a sharp object and he scratched on a metal part of the tractor everything to my wife. He placed a date and he signed it. That is a valid holographic will. Okay? Recall that under Article 804, the law is also categorical when it says the will must be executed in a language or dialect known to the testator. Therefore, if the will was written in English, but the testator did not know English, he knew only Filipino. But the lawyer who drafted the will explained everything to the testator. Yeah? He translated it. He interpreted it to the testator completely. And fully explained everything. That remains an invalid will. The law is not satisfied with mere translations, interpretations. The will must be in a language or dialect known to the testator. And there is a good reason for that. No matter how good the interpreter or translator may be, certain nuances of language are always lost in the process of translation or interpretation. It is not necessary, however, for the validity of the will that the will itself should contain a statement to the effect that it is in a language or dialect known to the testator. That is not required. Okay? So, if there is a dispute later on, the people opposing the probate of the will say, oh, this will is in English. Okay? The testator does not know English. If that claim is made, then that would necessitate the presentation of evidence. Evidence which can come from the outside, not necessarily from the will itself. So kung yung ganun na nangyari, the petitioner may present witnesses, neighbors and friends of the testator who will testify. Oh, that the testator actually knew English. He spoke English. That's admissible. Okay. Although, of course, if you're already lawyers and you're drafting a will, it would not harm if you include a statement in the will itself na, no, all men may this present, etc. I do hereby publish this, my last will and testament, in English, a language known to me. Okay yun. That will be quite helpful, but that is not necessary for the validity of the will. Okay? All right. Let's discuss the basic requirements for a valid notarial will. The basic requirements for a valid notarial will are found in Article 805 of the Civil Code. Every will, other than a holographic will, must be subscribed at the end thereof by the testator himself or by the testator's name, written by some other person in his presence and by his express direction, and attested and subscribed by 3 or more credible witnesses in the presence of the testator and of one another. All right. The first important thing which we have to remember in connection with paragraph 1 of Article 805 is that it tells us in very clear language one essential requirement for the validity of a notarial will. What is that? It must be subscribed at the end thereof by the testator himself or by the testator's name, written by some other person in his presence and by his express direction. The requirement, therefore, for subscription, for signing at the end of the will is an essential requirement for validity. If the will is a 5-page will and the testator affixed his signature on each and every page of the will, on the left margin, nandun, page 1, page 2, page 3, page 4, page 5. On all of the margins, nandun ang pirma ng testator. But he did not sign at the end of the will, that is not a valid will because it fails to comply with an essential requirement under Article 805. The next question we have to ask ourselves is, where is the end of the will? Okay. When the law mentions the end of the will, it refers not to the physical end, but to the logical end. Meaning, after the last testamentary disposition. Okay? So, kung 10 disposition yan, if there are 10 testamentary dispositions, the end of the will is after disposition number 10. Sa baba nun, that is the end of the will. Okay? That is where the testator should affix his signature. The law, of course, allows the affixing of the testator's name by a third person. Pwede, that is permitted. But, remember the 2 requirements. It must be done in the presence of the testator, and it must be by his express direction. Both requisites must concur. Otherwise, the will is void. If the testator is Juan Santos, and the person requested by the testator to write his name is Pedro Santiago, how should Pedro Santiago comply with Article 805? He should not forget to write the testator's name. Yun ang pinaka-importante. Because, ang sabi ng law, subscribe at the end by the testator himself or by the testator's name. So, pwede ang isulat ni Pedro Santiago is Juan Santos by Pedro Santiago. Pwede yan. Supposing that Pedro Santiago simply wrote by Pedro Santiago, hindi niya sinulat yung Juan Santos, that's not valid. Okay? Kasi maliwanag ang batas. Testator's name. Supposing that Pedro Santiago simply wrote Juan Santos, he did not bother to write his own name, Pedro Santiago, that is valid. Pwede yun. As long as in the attestation clause, the fact that Pedro Santiago wrote the testator's name in his presence and by his express direction is stated. Otherwise, if the attestation clause does not state the fact that Pedro Santiago wrote the testator's name in his presence and under his express direction, then the will is void. All right. The testator, of course, is the one ordinarily required to sign his will at the end and, of course, on the left margin of all of the pages of the will. In signing his will, the testator may use his usual signature. Okay? He can also use his initial. By initial, I refer to the shortened version of our signature. If the testator has a pen name, he happens to be a writer, and he has a pen name, he can use his pen name. Okay? Ang favorite na example ko dyan, yung si Nick Joaquin, a national artist. His pen name is Quijano de Manila. Okay? If he happens to be a movie star, meron siyang stage name or screen name, he can use his screen name. Halimbawa si Dolphy, o pwede, Dolphy. Yun ang ipirma niya doon. Okay, instead of using his legal name, Rodolfo Quezon. Okay? So, that's permitted. All right. Can the testator use a nickname? Pwede. Okay? In other words, in the law on wills, signature is taken from the root word signum, mark or sign. Okay? Now, can the testator sign his will with his thumb mark? Of course, alam natin, pwede yan. Okay? Kung gusto niyang medyo maiba, masyado marami nang gumagamit ng thumb mark, yung the mark of his big toe. Yung big toe ang ginamit niya, yun ang pwede rin yan. Okay? Why not? Okay? Because meaning na signature is mark. Okay? Extreme example, supposing he is a very romantic fellow, masyado makulay ang buhay, and he uses his lips. Okay? Medyo kinuskus niya sa stampad, tapos he made the imprint of his lips on the will with the intent to sign his will with the imprint of his lips. Would that be a valid will? Yes. As long as it can be established that that was really, he intended to use that as his sign or mark. Okay? Yun lang naman kailangan dyan. Alright. So, basically, he can use any sign or mark to validate his last will and testament. Okay. Next point. Of course, the law requires that a notarial will should have at least three or more credible witnesses. The law uses that adjective, credible. Is it necessary, therefore, during the probate of the will, that there must first be preliminary proof that the witnesses are credible individuals in the sense that they enjoy a high degree of respectability, reputation for probity and honesty in the community? The answer is no. The Supreme Court has already held. When the law says credible witnesses, the law simply means qualified or competent witnesses. So there is no need for a preliminary proof as to the reputation of the witnesses for probity, integrity, and honesty. Can there be more than 3 witnesses? Of course, yes. Walang problema. Kung masyadong marami mong kaibigan na gusto magtestigo, pwede yan. Okay? You can have even 10 witnesses or more. But you should not have less than 3. Kung 2 lang ang witnesses, the will is not valid. Okay. Paragraph 2 of Article 805 says, the testator or the person requested by him to write his name shall also sign, as aforesaid, each and every page thereof, except the last, on the left margin, and all the pages shall be numbered correlatively in letters placed on the upper part of its page. So, the testator and the witnesses are required under Article 805, Paragraph 2, to sign each and every page of the will except the last, on the left margin. Supposing they wanted to be different, they signed on the right margin. They would rather be called rightists rather than leftists. So sa kanang margin sila pumirma. Pwede ba yun? Pwede yun. They signed at the bottom margin or at the top margin. Pwede yun. As long as each page has the marginal signature of the testator and the three witnesses. Supposing that it is a 5-page will, it's perfectly executed, except that on page 3, you don't find the signature of the testator on any of the margins, or you don't find the signature of one of the three witnesses on any of the margins of page 3. Should the will be allowed? In this connection, you have the case of Icasiano versus Icasiano. That is the case where the oppositor practically threw everything, including the kitchen sink, to use a trite expression, against the petitioner. There was a will there. I think it had 5 pages. On page 3, there was a missing signature. Page 3 of the original of the will. There was a missing signature. One of the three witnesses did not sign on page 3 of the original of that 5-page will. What is quite amusing about the case is that, I always tell my students, when you are already lawyers and you are asked to assist in the execution of a will, always get these 3 individuals as much as possible, get these 3 types of individuals as witnesses. Sabi ko, number 1, kumuha ka one of the witnesses, yung pare o madre o pastor ng testator. Okay. Reason, whether you like it or not, these people have a very high degree of credibility. Okay? Rare is the judge who will not believe the assertions made by these people under oath. Okay? Pag pare o madre o pastor ang tumistigo dyan, under oath, sinabi, ganito nangyari, sigurado yung judge maniniwala. So, try to get as one of the witnesses. Yan. Number 2 kako, always try to get as another witness the attending physician of the testator. So that if there is some question about the physical condition or mental state of the testator, the attending physician will be able to handle the questions along that line. And third, sabi ko, always try to get as your third witness a lawyer. Bakit naman? If there is a question about due execution, siyempre, if your third witness is a lawyer, chances are, kahit na balik-balik ta rin yan on cross-examination, even by, he can handle the questions coming even from a very astute cross-examiner. In Icasiano, kaya nagkagulo-gulo, it was because of the failure of one of the witnesses who was a lawyer to sign on page 3. Ang pinagsimulan ng gulo yung abogado. All right. Anyway, so, the oppositor in that case opposed the probate of the will. I mean, that's not a valid, that's a forgery. Okay? So, that is a forgery. The signature there of the testate was forged. There was undue influence. Sabi. There was fraud. Okay? And of course, there was failure to comply with the formalities because one of the three witnesses did not sign on the margin of page 3. So that was the thrust of the opposition. Because of that opposition, ang ginawa ng petitioner, the petitioner presented to the court the duplicate original. There was a duplicate original also, and the duplicate original was perfect. It was signed by the testator and the witnesses on all the places where they are supposed to sign. So, perfect yung duplicate original. Sabi ng petitioner, if the original cannot be probated because of the absence of marginal signature of one of the witnesses on page 3, then let's just probate the duplicate original. Okay. The case reached the Supreme Court. Sabi ng Supreme Court, in Icasiano versus Icasiano, the oppositors are faced with a dilemma. If they are opposing the allowance of the original of the will because of the absence of marginal signature of one of the witnesses on page 3, there is no reason why they should also oppose the probate and the allowance of the duplicate original, which after all contains all of the required signatures at all of the appropriate places. Okay? So, sabi ng Supreme Court, it would seem, under the circumstances, that the failure of one of the witnesses, Attorney Natividad, if I remember correctly, to sign on page 3 was simply due to inadvertence, due to the simultaneous lifting of 2 pages. Yun lang ang dahilan kung bakit hindi na-pirman yun. Now, if you're asked a problem, 5-page will, page 3 does not have the marginal signature of either one of the witnesses or the testator. Should the will be allowed? I submit that the ruling in Icasiano should be limited only to the precise circumstances which obtained in that case. And the most important thing you have to remember in Icasiano is this. In that case, there was a duplicate original. There can be no doubt at all in Icasiano that there was a validly executed will because there was that duplicate original. If, on the other hand, you only have one copy of the will, yung original lang, and that single copy lacks one of the required marginal signatures, I submit, following earlier rulings of the Supreme Court, the will should be disallowed. Put another way, the ruling in Icasiano has not done away with the previous rulings of the Supreme Court in many cases where the court invalidated wills because of the absence of the required marginal signatures. The ruling in Icasiano did not and should not be interpreted to mean that we can now do away with the requirement for marginal signatures on each and every page as expressly mandated by paragraph 2 of Article 805. So kung isang kopya lang, kulang ng marginal signature, I submit the will should not be allowed. All of the pages should be numbered correlatively in letters placed on the upper part of each page. The precise location of the numbering is not really essential for validity. In other words, while the law says the numbering should be placed on the upper part of each page, if they place the numbering on the lower part of each page, pwede yun. They place it on the left margin or on the right margin, okay yun, basta may numbering. As long as all of the pages are numbered correlatively in letters, okay? And what is meant by numbering correlatively in letters? Ibig lang sabihin yun, you spell out. So, instead of simply writing the Arabic numeral yung 1, okay, dapat, if you want to follow the provision literally, you write the word 1. Next page, 2. Yan ang correlative numbering in letters. Eh kung tinatamad yung nagdadrap ng dokumento, 1, 2, ang ginamit niya, Arabic, pwede rin yan. Okay? that will not affect the validity of the will. You can use Arabic numerals, Roman numerals, even letters of the alphabet. Page A, page B, page C, as long as there is correlative numbering. Okay? Now, supposing that it is a 5-page will, pages 2, 3, 4, and 5 are numbered. Page 1 is not numbered. Should the will be allowed? The answer is yes. It should be allowed. Why? Because even if page 1 does not have a numbering, there can be no doubt at all that that is page 1. Nandun yung simula ng will. Last will and testament of so-and-so, etc. No all men by this presence. Okay? And then you look at the next page, it's page 2. So that must be page 1. Okay? So if page 1 is not numbered, but the other pages are numbered correlatively, as required by law, that should not affect the validity of the will. Okay. The witnesses are required to sign, among other things, on the left margin of each and every page of the will. Just like the testator, the witnesses can also sign with their pen names, with their nicknames, with their screen names. Can they sign with their thumb marks? I submit that they can. Okay? As long as, in reality, they know how to read and write. Because one of the requirements for witnesses is that they should know how to read and write. So as long as they are actually literate, they can sign the will with their thumb marks, if they intend that as their signatures. Okay. Would it make any difference if the witnesses signed the will ahead of the testator? Halimbawa, the testator asked the witnesses, oh, you sign ahead. Muna na kayong pumirma. And the witnesses signed, including the attestation clause. They all signed. Only after the witnesses had signed did the testator sign the will. Should that be a valid will? I think the better view is that as long as there is no interruption, as long as everyone signed during one single continuous occasion, the will should be valid. Okay? Actually, the thrust of those who believe otherwise is that if the witnesses signed ahead of the testator, they're actually attesting to a falsehood. Because they will be signing in the attestation clause that the foregoing will was, among other things, signed in our presence by the testator. Eh, hindi pa naman nagaganap yun because the testator has not yet signed. Therefore, if they do that, they would have been attesting to a falsehood. But I repeat, I think the better view, I submit the better view. And, of course, this is merely an obiter, but the Supreme Court said so in Cañeda versus Court of Appeals. Although the statement of the court there is clearly an obiter. As long as everyone signed during one single uninterrupted continuous occasion, the will should be considered valid. Okay. If, however, the testator invited the witnesses to his residence on January 1, and he told them, oh, this is my last will and testament. I want you to be the witnesses. Would you please sign? Pirma ang witnesses. After the witnesses had signed, the testator had not yet signed. No? After the witnesses had signed, sabi ng testator, let's meet again on January 6. I want to think about this. Sabi niya, kung talagang ito na ang last will ko. And they met on January 6. And it was on that date when the testator signed. I submit that in that case, the will should not be allowed. Because it's clear there that when the witnesses attested the execution of the will, they were attesting to a falsehood. Because the testator had clearly not yet signed as of January 1. As a matter of fact, the testator signed only several days later, January 6. If a third person has been asked by the testator to write his name on the will for him, sabi natin, it must be done under the express direction of the testator and in his presence. The mere silence of the testator or his failure to object to the signing by a third person is not the express direction contemplated by law. So, if the testator is very sick, nandiyan siya sa sangkatutak na mga tubo na nakadikit sa kanya, and his lawyer, who had earlier drafted the will in accordance with the instructions of the testator, told the testator, in the presence of the three witnesses, and let's even say, even the notary public was there, sabi ng lawyer, "Oh, Mr. Testator, I don't think you are in a position to sign this will yourself. So, unless you have an objection, I will sign this will for you." The lawyer waited for about a minute or two. And then later on, wala naman sinabing testator, nakatingin lang yung testator. Sabi ng lawyer, "Oh, wala siyang objection. So, I will sign the will for him." That is not a valid will. Walang express direction. Mere failure to object, mere silence is not express direction. The express direction, however, need not be done verbally. If the lawyer asks the testator, "Mr. Testator, do you want me to sign this will for you?" Sabi ng testator, tumango, he nodded. Okay na yon, pwede na yon. That is already an express direction. Okay. It must be done, of course, in the presence of the testator. So, if the testator orders his lawyer, "Oh, attorney, ipirma mo na ang pangalan ko dyan." O, sige ho. Okay, and the three witnesses were there. "Oh, si attorney ang pipirma para sa akin dyan." But it was too crowded inside that small hospital room. So the lawyer and the witnesses went to another room. Patay na. That's not a valid will. Because the signing by the third person must be done in the presence of the testator. Supposing that the testator was really very sick. So sabi niya sa lawyer, the three witnesses were already there in the hospital. Sabi niya, "Attorney, I want to make my will." O sige, ano ang ilalagay natin? O ito, sabi, dinikta. The testator dictated the provisions. Lawyer took notes. And then, sabi ng testator, "Attorney, I want you to sign that will which you will be drafting. I want you to sign that for me." O, takbo yung lawyer sa kanyang opisina. He encoded the will as dictated by the testator. He rushed back to the hospital carrying the printed will, ready for signature. Pagdating niya doon, the testator was already unconscious. He had already sunk into a coma. Hindi pa naman period. Coma pa lang. Okay. Sabi nung lawyer doon sa mga testigo, "Oh, we all heard his earlier instructions." Sabi niya, "I should sign the will for him." So right there and then, inside that room, the testator affixed the testator's name on the will. Is that a valid will? The answer is no. Because while it was done in close physical proximity to the testator, the requirement of presence was no longer satisfied. Why? The testator was no longer conscious of what was going on. Presence requires not just close physical proximity, the absence of any obstruction, it also requires a consciousness, an awareness of what is going on. Okay? So in that case, the will should not be allowed. Okay. Next point. The presence of the notary public is not required at the time of the actual signing of the will by the testator and the witnesses. Hindi kailangan nandun na yung notaryo publiko. Okay? Ang kailangan na lang doon, testator and the 3 witnesses. Alright. Of course, when it comes to the acknowledgement of the will, syempre, nandun yung notary public. Okay. Next point. The law in Article 805 gives us, in paragraph 3, the matters which are required to be stated in the attestation clause. Okay, so what are these? Number 1, it should state the number of pages used upon which the will is written. Okay. Number 2, it should state the fact that the testator signed the will and every page thereof, or cause some other person to write his name under his express direction in the presence of the instrumental witnesses. And number 3, and that the latter, meaning the instrumental witnesses, signed the will and all the pages thereof in the presence of the testator and of one another. These are the 3 essential things. Okay, so number of pages of the will, that must be stated in the attestation clause. It must state that the testator signed the will and all the pages thereof, or caused some other person to write his name under his express direction in the presence of the instrumental witnesses. And number 3, it must also state that the witnesses signed the will and every page thereof in the presence of the testator and of one another. Now, supposing that an essential fact required in paragraph 3 of Article 805 is not stated in the attestation clause. Supposing that the attestation clause does not state the total number of pages used in the will the will be necessarily invalid? Or is it still possible to probate that will kung walang number of pages na naka-state sa attestation clause? If what is missing in the attestation clause can be found in another part of the will may still be allowed. Okay? As long as what is missing can be found in another part of the will. Okay. For example, total number of pages is not stated in the attestation clause. But, as happened in one case, in the notarial acknowledgement, the total number of pages of the will is stated. That is substantial compliance. Supposing that the total number of pages is not stated in the attestation, but in the last paragraph of the will, just above the testator's signature, yung sa end ng will, di ba usually ang mga end ng mga dokumento, in witness whereof, okay, I hereby sign this, my last will and testament, consisting of, sinabi doon, 5 pages. Can the will be allowed? Yes. Because while that element is missing in the attestation clause, it is nonetheless found in another part of the will itself. In other words, there is no need to introduce extrinsic evidence. Supposing that the attestation clause does not categorically state that the testator signed each and every page of the will. Ang sinabi lang, among other things, the foregoing will was signed by the testator. Hindi sinabing foregoing will and each and every page thereof. Sinabi lang, the foregoing will was signed by the testator. Can the will be allowed? The answer is yes. As long as each and every page of the will, in fact, contains the testator's signature. Okay? So, although the attestation clause does not state that the testator signed each and every page of the will, ang sinabi lang is, among other things, that the foregoing will was signed by the testator in our presence. Hindi sinabing, foregoing will and every page thereof was signed in our presence. The failure to state expressly that the testator signed every page of the will may be deemed cured if upon examination of the will, each and every page thereof bears the signature of the testator. But if what is not stated in the attestation clause is the fact that the testator signed in the presence of the witnesses, nakalagay lang doon, total number of pages, foregoing will has 5 pages, the testator signed the foregoing will and every page thereof, and we, the witnesses, signed the will and every page thereof in the presence of the testator and of one another. What is missing? It does not state that the testator signed in the presence of the witnesses. Kung yun ang defecto ng attestation clause, that defect will not be cured. Will not be cured. Even if you find the testator's signature appearing on each and every page of the will side by side with those of the witnesses. Because the mere fact that the signature of the testator appears on each and every page of the will side by side with those of the witnesses will not prove that the testator affixed his signature in the presence of the witnesses. Okay. Presence is required. If the testator, for example, invites the 3 witnesses to his residence on January 1, and he tells them, I have decided to make my last will and testament, and I want you to be the 3 witnesses. And then he shows them his will. Oh, sabi niya, ito yung will ko. I already signed this. Sabi niya, oh, ito, signature ko yan. Page 1. Page 2, signature ko yan. Page 3, signature ko yan. At the end of the will, yan, signature ko yan. And then he asks the witnesses to sign as witnesses. Is that a valid will? It is not a valid will. The mere admission or acknowledgement by the testator that the signatures already appearing in the will are his is not enough. The law requires that the signature of the testator should be affixed in the presence of the witnesses. If the witnesses were not actually present when the signature of the testator was affixed, that is not a valid will. Even if he subsequently admits to them na pirma niya yung mga yon. Testator must sign in the presence of the witnesses. The witnesses must sign in the presence of the testator and of one another. When is there presence? There is presence when there is close physical proximity and the parties are situated in relation to each other in such a way that there is no physical obstruction which would prevent one from seeing the other by simply turning his gaze in the proper direction. I am signing my will on this table. You are one of the witnesses. And, well, you happen to be standing by that door, inside the room, but by the door. And there was a commotion going on in the hallway, and you were looking out. Is there signing in your presence? The answer is yes. The law does not require the testator and the witnesses to actually see each other sign to satisfy presence. All that is required is that they could have seen each other sign. There being no physical obstruction, okay, so that they could have seen each other sign by simply turning their gaze towards the proper direction. That's all that the law requires. So, the testator signed the will inside the same room with the three witnesses. Nandun sila sa isang same room. While the testator was signing, one of the witnesses was busy watching a movie on television, or was watching the newscast, or was busy texting his girlfriend. Okay. And after the testator has signed, the testator called the witness, "Oh, turn mo na, you sign." Is there signing in the presence of that witness? Yes. Because he could have easily seen the testator. They were inside the same room, walang physical obstruction. He could have seen the testator sign by simply looking at the proper direction. There is presence. If the testator is blind, how do we satisfy the requirement of presence? Through the use of other senses. What other senses can you possibly use? The sense of touch. Okay. Hindi naman kailangan na akapin ng testator yung witness habang pumipirma. The testator may, for example, hold the will while it is being signed by the witness and sense through his fingertips, okay, the action being done by the witness. Or the witnesses may give him a running account of what is going on. Oh, Mr. Testator, I am now signing on page 1, I am now signing on page 2, etc. Okay. Sense of hearing may also be used. Other senses. Okay? All right. Next point. Of course, Article 805 says, if the attestation is in a language not known to the witnesses, it shall be interpreted to them. Supposing that the attestation is in a language not known to the testator, should the will be allowed? The answer is yes. While it is not possible to have a notarial will without an attestation clause, nonetheless, the fact remains that the attestation is the act of the witnesses, not of the testator. Okay. Let us assume that it is a 5-page will. Page 5 contains only the attestation clause. Yun lang ang nandun sa page 5. Attestation clause lang. The testator signed at the end of the will on page 4, and he also signed together with the witnesses on the left margin of pages 1, 2, 3, and 4. On page 5, however, you only find, of course, the attestation clause. Below the attestation clause, on page 5, you find the signatures of the 3 witnesses. But you don't find on the left margin of page 5 or on any of the margins of that page the testator's signature. In other words, page 5 is not signed by the testator. Should the will be allowed? The answer is yes. Since page 5 contains only the attestation clause, the testator has nothing to do with the attestation clause. So even if he failed to sign on any of the margins of page 5, since page 5 after all contains only the attestation clause, the will in that case should be allowed. Okay. Let us assume, again, it is a 5-page will. The testator and the witnesses signed on the left margin of pages 1, 2, 3, 4, and 5. Okay? So, left margin ng lahat ng pages may pirma ng testator and the 3 witnesses. The 3 witnesses, however, did not sign below the attestation clause. Although you find their signatures on the left margin of the page containing the attestation clause. Should the will be allowed? The answer is, it should not be allowed. Okay? Maliwanag na waliwalag yan sa Azuela. Why? Because the Supreme Court in the case of Cagro versus Cagro said the will should not be allowed. Why? According to the court, the absence of the witnesses' signatures below the attestation clause negates their participation insofar as that attestation clause is concerned. After the ruling in Cagro, there came the new civil code. And among the new provisions in the new civil code, of course, was the doctrine of liberal interpretation under Article 809. In the absence of bad faith, forgery, or fraud, or undue and improper pressure and influence, defects and imperfections in the form of attestation or in the language used therein shall not render a will invalid if it is proved that the will was in fact executed in substantial compliance with the requirements of Article 805. Now, because of that new provision, and there were some civilists to say, the ruling in Cagro has been rendered ineffective because we now have the doctrine of liberal interpretation. But even before the ruling in Azuela, where this was again the issue, I have always maintained Cagro was still good. So, dating ng Azuela ruling, sabi ng Supreme Court, pag ganito ang nangyari, although they signed on the left margin, if they did not sign below the attestation clause, the will is void. Why? Because, sabi ng court, the requirement for marginal signatures is a separate, distinct requirement from the requirement that there should be an attestation clause. Magkaibang requirement yan. The signatures of the witnesses on the left margin simply complies with the requirement for marginal signatures. That is not compliance with the other requirement. Anong other requirement? The requirement that there should be an attestation clause. If the attestation clause is not signed by the witnesses, that is not a valid attestation clause. Precisely because it is not signed by them. So the will should be considered invalid. Yung Azuela versus Court of Appeals, yan ang example ng will na halos lahat ng depekto nandiyan na. Okay? Yan ang isang principal defect. Attestation clause not signed by the witnesses. The attestation clause in that case does not also contain the number of pages used in the will. And the supposed acknowledgement of that will was not really an acknowledgement. It was simply in the form of a jurat. At least, syempre, alam naman natin ang difference ng jurat at acknowledgement. Okay? Ang acknowledgement yung personally came and appeared, etc. Ganyan. Yung jurat, subscribed and sworn to before me. Ganon ang ginawa sa Azuela. Kesang katutak talaga ang problema ng will doon. Best example of a grossly defective will. Next point. The will must of course be acknowledged before a notary public. You don't have a valid notarial will if it has not been acknowledged before a notary public. I repeat, the notary public need not be present at the time of actual signing by the testator and the witnesses. Kahit na wala yung notaryo doon, pwede yan. As a matter of fact, it's perfectly all right if the date of execution of the will is stated in the will itself is different from the date of acknowledgement. Walang problema yon. Because it can happen that the will is executed today and it's only 1 week later when it is acknowledged before a notary public. That does not affect the validity of the will. That's a perfectly valid will. All right. The notary public before whom the will is acknowledged must be properly authorized to act. If the will is acknowledged before a notary public in Quezon City, but his notarial commission is for the area of Caloocan, that is not a valid will. If you are a notary public in Caloocan, you should only acknowledge documents there. Wala kang karapatang magnotaryo sa labas ng teritoryo, outside of the area of your notarial commission. If you should notarize a will outside of the area of your notarial commission, the will is void. Because a notary public is bereft of power to perform any notarial act outside of the area of his notarial commission. Nangyari nito in the case of Guerrero versus Bihis. Ang notarial commission sa Caloocan na pina-acknowledge sa kanya sa Quezon City, clearly void. All right. The notary public, of course, is not required to retain a copy of the will or to file one with the office of the clerk of court. Ordinarily, when you acknowledge a document before the notary public will ordinarily get at least 2 copies. One for his own files and another copy which he will submit to the clerk of the court which issued his notarial commission. Later on, that copy which had been forwarded to the clerk of court will ultimately find its way to the National Archives. Kaya pag may hinahanap kang matanda ng dokumento, you can possibly get a copy in the National Archives. The notary public is not required. Basta it's a last will and testament. The obvious purpose is to preserve the secrecy of the will. Okay? Kasi kung mag-iiwan ng kopya sa notaryo publiko, baka masilip ng mga ibang tao yung contents ng will at baka madali ang buhay ng testator. Yung mga hindi nabigyan ng malaki-laki under that last will and testament. Okay. Not just the testator, but the witnesses as well must acknowledge before the notary public. They are not required, however, to acknowledge the will in each other's presence. Hindi katulad ng execution, where everyone must sign in the presence of the others. When it comes to acknowledgement, they can do it separately. The testator can acknowledge before the notary public on January 1. Witness number 1 may acknowledge before the notary public alone on January 2. Witness number 2 may acknowledge alone before the notary public on January 3. Pwedeng kanya-kanyang acknowledgement yan. Presence is not required. If one of the 3 witnesses is also the notary public who notarized the will, of course, walang kaduda-duda, that is not a valid will. Because the notary public, who is also one of the 3 witnesses, cannot dichotomize himself and assume 2 different personalities. One personality as a witness, acknowledging before himself, this time as a notary public. Okay. That's a little bit mind-boggling. Okay? Hindi pwede yun. If there are 4 witnesses and the will is acknowledged before one of them, he happens to be a notary public, pwede pa. Because there are 3 other competent witnesses to the execution of the will, excluding the notary public. Okay. Remember the special rules for people who are under a disability. If the testator is deaf or a deaf-mute, the requirements are found in Article 807. He must personally read the will if he is able to do so. Otherwise, he shall designate 2 persons to read the will and to communicate to him in some practicable manner the contents thereof. Okay. So, it is the testator who will designate who these 2 people are who will read the will assuming the testator cannot read, and thereafter communicate to him in some practicable manner the contents thereof. And while the law does not categorically so state, it is, I suppose, understood that the two individuals will communicate the contents one after the other. Hindi naman pwedeng sabay yung dalawang tao nagkukumpas sa testator kung ano yung contents ng will. Isa-isa lang, mahinang kalaban. Ha? So, yung isa muna, basahin niya, tapos communicate niya, after his through, yung isa naman. Siya naman na magkukumpas doon. Alright. If the testator is blind, tandaan lang natin ha, 2 readings. Okay? If the testator is blind, the will must be read to him twice. And, you know, the law even specifies who should do the reading. Once by one of the witnesses, and again by the notary public before whom the will is acknowledged. If the will is read only once to the testator, sabi ng testator, tama na yung isang basa. Nakababasa lang yan, babasahin mo na naman yan. Sige na, tapos na yan, okay na yan. That's not a valid will. It is not for the testator to waive a second reading. That's a mandatory legal requirement. Okay? Which must be complied with, otherwise the will be invalid. The obvious purpose is to prevent the commission of fraud. Okay. If the testator is illiterate, walang specific provision, but I submit that the same rule should be applied. Same rule for blind testators. Kasi ang illiterate testator, para ding bulag yan. Kahit na ipagwagwagan mo sa harap ng mata niyan yung will, parang bulag yan, hindi nababasa. These are just meaningless signs and symbols insofar as is concerned. So, if the testator is illiterate, the will must be read to him twice. Just like in the case of a blind testator. Okay? Alright. You remember, however, the case of Alvarado versus Gabiola, where the testator was blind. The will was read only once. And not only that, it was not read by the notary public nor by one of the witnesses. Ang nagbasa ng will was the lawyer who drafted it. And yet, the will was allowed there. Why? Because while the lawyer was reading the will, yung nagdraft ng will, they were all seated around the table. The notary public was there. The 3 witnesses were there. And they each had a copy of the will. So, meron silang kopya ng will. So, basa si attorney, they were following his reading, word for word. Sinusundan lang yung basa, kung tama ang binabasa niyan. Okay? After that, the testator said, that is my will. And so, it was signed, it was acknowledged for the notary public. The court said there is substantial compliance. And correctly so. Walang duda. There was substantial compliance with the requirement of the law. Alright. Kasi nandun naman silang lahat, and notary public and the 3 witnesses were each given a copy of the will, and they were able to follow the reading of the lawyer, word for word. Alvarado versus Gabiola. In the absence of bad faith, forgery or fraud, or undue and improper pressure and influence, defects and imperfections in the form of attestation or in the language used therein shall not render a will invalid if it is proved that the will was in fact executed and attested in substantial compliance with the requirements of Article 805. That's the doctrine of liberal interpretation. A holographic will is very simple. All that you have to remember is that it must be entirely written, dated, and signed by the hand of the testator. If the testator does not have hands, putol ang kamay niya, and he uses his mouth to write, he clenches the pen in his mouth. Can he make a holographic will? Yes. Okay. the use of the phrase by the hand of the testator should not be taken literally. Okay? If he uses his foot to write, that is still a valid holographic will. All right. Remember that you cannot have a valid holographic will unless it is dated. If it does not have a date, that's not a valid holographic will. Ideally, it should be a complete date, month, day, and year. But it has already been held by the Supreme Court. Even if only the month and the year are indicated, that's sufficient in the absence of any indications of bad faith, forgery, or fraud. So in one case, ang nakalagay lang Feb, F-E-B /61. That was considered as a valid date. Okay? Ang problema lang noon, supposing the testator made 2 wills in the same month, parehong Feb 6/1 ang date. There is a problem there. How do you determine which is the later will? No problem if the provisions are consistent with each other, but supposing they are inconsistent with each other, there would be a problem there. But at any rate, that is, according to the court, a sufficient date. The date may be placed anywhere in the will. In one case, I referred to Labrador versus Court of Appeals. The date, there was even no separate date. The date was simply mentioned in passing in one of the testamentary provisions. Nabanggit lang yung petsa in one of the testamentary provisions. And it is on this day, etc., when I am giving this property. Sabi ng Supreme Court, that is sufficient. The fact remains that there is a date, although the date is simply mentioned in passing in one of the testamentary provisions. Can a blind man make a holographic will? Yes, as long as he knows how to write. Okay, walang problema yon. All right. You also take into account the requirements when it comes to the probate of a holographic will as to the number of witnesses. You find this in Article 811. If there is no opposition, at least one witness who is familiar with the handwriting and signature of the testator must be presented to identify the will. If there is an opposition, the law says at least 3 such witnesses shall be presented. In an earlier case, the Supreme Court has considered the requirement of 3 witnesses as merely directory. According to the court, in the case of Azuala versus Singson, the requirement of 3 witnesses in case there is an opposition to the probate of a holographic will is merely directory, not mandatory. Why? Because the availability of 3 witnesses who are all familiar with the handwriting and signature of the testator is something which is not totally within the control of the petitioner. For all you know, even if the petitioner looks far and wide for such witnesses, he may not be able to locate 3 who can truthfully assert under oath that they are familiar with the handwriting and signature of the testator. That is precisely the reason why the law allows for the presentation of expert witnesses in Article 811. In the subsequent case, however, of Codoy and Ramonal versus Kalugay, the Supreme Court, basing its decision on the use of the word shall in Article 811, held that the requirement was mandatory. You cannot probate a holographic will unless you can present a copy of the will, either an original copy or at least a photocopy. Why? Because the only guarantee of authenticity of a holographic will is the fact that it is supposed to be entirely written, dated, and signed by the hand of the testator. The court, therefore, must always be given the opportunity to itself examine the will and determine whether, in fact, it is in the handwriting and signature of the testator. If the one and only copy of a holographic will has already been lost, so that there is no existing copy, Although it may be a very simple holographic will, isa lang ang provision, I give everything to my wife, date, signature, and even if a lot of people were able to see it when it was still extant, forget about the probate of that holographic will. You need at least a photocopy. Otherwise, forget about probate. Next point. The testator may sign his holographic will just like a notarial will with his full signature. He may use his initial, yung shortened version of his signature. His nickname, his pet name, his stage name, he can use in signing the will itself. When it comes to any alterations or insertions, however, the law is categorical. The law requires that for any insertion or cancellation or alteration in a holographic will, it must be authenticated with the full signature of the testator. Therefore, insertions, alterations, cancellations cannot be authenticated by using any other signature other than the full signature of the testator. By full signature, we mean the usual customary signature of the testator. It does not necessarily have to include the complete name and surname. Hindi. Kung ano yung usual, customary, that is considered the full signature of the testator, as opposed to his initial, the shortened version of his signature. Okay. You remember the provisions of Articles 812 and 813. If the testator makes additional dispositions in a holographic will, halimbawa, tapos na yung holographic will niya, okay? And then, he makes additional dispositions. May naalala siyang mga gusto niya idagdag, o sinulat niya, addition. The additional dispositions must be signed and dated. Otherwise, they are not valid. Okay. Where should the testator sign his holographic will? In the case of a notarial will, alam natin, the law is categorical. He should sign at the end thereof. The law does not categorically state where the testator should sign his holographic will. But if we look at Article 812 of the Civil Code, that article indicates where the testator should sign. Bakit? Because in Article 812, the law says, dispositions in a holographic will appearing or written below the signature of the testator must be dated and signed in order to be valid as testamentary dispositions. In other words, the law assumes that the last thing you will find in a holographic will is the testator's signature. That is the reason why the law makes the testator's signature as the point of reference insofar as additional dispositions are concerned. So, just like in a notarial will, although the law does not categorically so state, the testator should also sign at the end of the holographic will, after the last testamentary disposition. Okay. If the testator made the following will, May 7, 1985, I give everything to Jose Santos. Signed, Pedro Santos. Okay. That would obviously be a valid holographic will. If he makes the following additional dispositions, okay, sabi niya, I give 10,000 to Maria Santos, and then another one, I give my house to Juan Esculin. These two additional dispositions are not valid. Why? Because the law requires that they should be dated and signed. The fact that they are not valid, however, will not affect the validity of the will. The will remains valid. Okay? Ito lang dalawang additional ang void. Okay. Supposing that the first disposition is signed. The second disposition is signed and dated. 12/7/88. Okay. In this case, both dispositions are valid. Since the preceding disposition is signed but not dated, the date appearing with the last disposition, which is both signed and dated, will operate to validate the preceding disposition, which is signed but not dated. Okay. What's the reason for that? The reason is that the law can assume, okay, the law can assume that these two dispositions were actually made at the same time. Okay? Now, if the preceding disposition, however, is dated but not signed, alam mo, may date yung first disposition. There is a date. Sabihin natin na 2/18/86. And the last disposition has both a date and a signature. Only the last disposition will be valid. The preceding disposition will not be validated. Ang provision lang is, if the preceding disposition is signed but not dated, and the last disposition has both a date and a signature, all of the preceding dispositions, which are signed but not dated, will be validated. But the reverse is not true. If the preceding dispositions are dated but not signed, and the last disposition has both a date and a signature, the preceding dispositions will not be validated. Why? Because in this case, the law cannot assume that they were made at the same time. May kanya-kanyang petsa. Okay? All right. Next point. As I mentioned a while ago, if there are any insertions or cancellations in a holographic will, this must be authenticated with the full signature of the testator. And we said, by full signature, we simply refer to the usual customary signature of the testator. You remember that case of Calao versus Reloba, however. Okay. So, halimbawa, ang nangyari ganito. The testator, Pedro Santos, crossed out the name of Jose and inserted Maria. So, palang lumalabas na ang gusto na niya, his heir will be Maria Santos instead of Jose Santos because he canceled the name of Jose and inserted the name of Maria. He does not, however, authenticate this with his full signature. Question, who will be considered as the duly instituted heir? The answer, neither of them. Why? In the case of the insertion of the name of Maria, obviously, that's not a valid insertion because of the absence of authentication. So, pwede nating sabihin, ay yung pala eh. So, the cancellation of the name of Jose should not also be considered a valid cancellation. Therefore, it should be as if Jose is still the instituted heir. Kung hindi valid yung cancellation ng pangalan niya. But the point is that the principal rule in testamentary succession is always the ascertainment of the intention of the testator. If we give the entire estate to Jose by saying, well, the cancellation of his name is not a valid cancellation because of the absence of authentication, we will be ignoring the obvious change of heart on the part of the testator. And that cannot obviously be done. So neither of them can be considered as the instituted heir under the circumstances. If a third person makes an insertion in a holographic will, what will be the legal consequence? Tolentino says there are 4 possible scenarios. Okay. First situation. If a third person makes an insertion in a holographic will without the knowledge and consent without the knowledge and consent of the testator, you simply ignore the insertion. The insertion is considered as not written. The will remains valid. Second situation, a third person makes an insertion in a holographic will with the consent of the testator. Okay? The will remains valid, but the insertion is void. Kahit na may consent siya, the will remains valid. Only the insertion is void. Third possible situation, the third person makes an insertion in the holographic will, not only with the consent of the testator, but the testator even authenticates it, the insertion with his full signature. Naloko na. The entire will is void. Why? Because by authenticating the insertion made by the third person, the insertion becomes a part of the will. And that will no longer be able to satisfy the fundamental requirement for holographic wills, that it should be entirely written, dated, and signed by the hand of the testator. Fourth scenario, the third person makes an insertion in the holographic will simultaneous with the execution of the will. So the testator, let's say, is writing a rather long holographic will. Nakaka 3 pages na siya. Nangawit. Nandun yung kanyang kumpare. Pare, sabi niya, dikta ko sa iyo ha, isulat mo. The entire will is void. Because that is not entirely written, dated, and signed by the hand of the testator. If in a holographic will, there are some provisions which contain alterations which are not duly authenticated, you only invalidate the affected provisions or the particular insertions concerned. The other provisions which are not altered will not be affected. They will remain valid. With respect to the applicable law, if a person wants to make a will, okay, insofar as Filipinos are concerned, as long as they are here in the country, they can only follow one law, our law, the Civil Code of the Philippines. Okay. If a Filipino is abroad and he wants to make a will, what formalities can he observe? He can observe the law of the place of execution, lex loci celebrationis, applying Article 17 of the Civil Code as well as Article 815. The forms and solemnities of contracts, wills, and other public documents shall be governed by the law of the place where they are executed. If a Filipino is abroad, can he make his will in accordance with the formalities prescribed by the Civil Code? The answer is yes. The Civil Code does not categorically and expressly authorize Filipino citizens who are abroad to make their wills abroad in accordance with the formalities prescribed by Philippine laws. But the Civil Code allows foreigners who are abroad to make their wills abroad in accordance with the formalities prescribed by Philippine laws. If foreigners are allowed to make their wills abroad in accordance with the formalities of the Civil Code, there is no rhyme or reason why Filipino citizens who are abroad and who are presumed to be more conversant with the formalities of Philippine laws should not be allowed to do the same. So, commentators are practically unanimous in the view that even in the absence of an express categorical statement in the Civil Code regarding that matter, Filipinos who are abroad should be allowed to make their wills abroad in accordance with the formalities prescribed by Philippine laws. Of course, there is no question, even under Article 17, if the act is done before the diplomatic or consular officials of the Republic of the Philippines in a foreign country, then there is no question. The formalities of Philippine laws shall govern their execution. Okay. If an alien is here in the Philippines and he wants to make a will, what formalities can he follow? He can follow the formalities prescribed by Philippine law, or he can follow the formalities prescribed by the laws of his own country. If an alien is abroad and he wants to make a will, What formalities can he follow? He has 4 choices. He can follow the law of his nationality. He can follow the law of his domicile. He can follow the lex loci celebrationis, the law of the place of execution, or he can follow the formalities prescribed by Philippine law. Okay? If X is a citizen of Germany, domiciled in France, presently in Japan as a tourist, he can make his will in accordance with German law, or the laws of France, or with Japanese law, or with Philippine law. When it comes to Filipino citizens, however, regardless of where they may be, they can never ever make a joint will. Basta Pilipino ka, kahit saan lupalop ng mundo ka magpunta, you can never make a valid joint will. What's a joint will? It is a single last will and testament executed by 2 or more testators. The use of a single sheet of paper does not necessarily make it a joint will. If H and W are spouses, the husband wrote his will on this page, and at the back, the wife wrote her will, that's not a joint will. Those are 2 separate, distinct wills. But if they wrote only one will and they both signed it, joint will yan. Okay? That's prohibited. That's void. As long as you're a Filipino. Even if you execute it in a place where joint wills are allowed. Basta Filipino ka, kahit nasaan kang lupalop, you can never make a joint will. Okay. H and W are husband and wife. Let us assume that they executed a joint will while in Brazil. Okay. Let's assume that Brazilian law allows joint wills for spouses. Is that will valid? Void under our laws. Okay. Supposing that W is Brazilian, H is a Filipino. So, while in Brazil, let's assume Brazilian law allows joint wills. While in Brazil, they made a joint will. Can we accord validity to that will? Valid insofar as W, the Brazilian, is concerned. Void insofar as H, the Filipino, is concerned. If H and W, both Brazilians, make a joint will in Brazil, their own country, can we recognize that joint will? Yes. Nung pakialam natin doon, parehong Brazilian yan. Their own national law allows them to make joint wills. Supposing H and W, both Brazilians, make the joint will here in the Philippines. Let's assume that Brazilian law allows joint wills. Can we recognize the joint will? 2 views. One view, that will is void because it's contrary to public policy. It was made right in the Philippines. Or the other view, valid. Why? Even the civil code allows foreigners who are here in the Philippines to make their wills in accordance with their own national law. After all, Brazilian law, their national law allows joint wills. So, that should be considered the valid will, even on the basis of the provisions of the civil code. What about the intrinsic validity of wills? Remember, pagdating sa intrinsic validity, hindi forms, kundi intrinsic validity, whether particular provisions are valid. It is always the national law of the decedent. Okay? Remember the 4 aspects of succession which are always, and I mean always, governed by the national law of the decedent. You find the first 3 in Article 16 of the Civil Code. You find the 4th in Article 1039. Order of succession, amount of successional rights, intrinsic validity of testamentary provisions, and under Article 1039, capacity to succeed. Regardless of what the testator may say in his will. Halimbawa, testator ay Koreano. Sabi nung Korean na testator, I want my estate to be distributed in accordance with Philippine laws. Intrinsic validity, order of succession, all of this will be governed by Philippine laws. Kahit ano sabihin niya, hindi pa rin. Okay? It will still be Korean law, which will govern the 4 aspects of succession. I repeat, order of succession, amount of successional rights, intrinsic validity of testamentary provisions, and capacity to succeed. Let's now talk about witnesses to wills. Okay. What are the qualifications for witnesses? Okay, of course, sound mind, 18 years of age or more, able to read and write, not blind, deaf, or dumb, domiciled in the Philippines, and must not have been previously convicted of falsification, perjury, or false testimony. Remember the provisions of Article 823. If there is a legacy or devise in a will given to one of the witnesses to that will, or given to his parent or spouse or child, that legacy or devise is considered void insofar as that witness, his spouse, his parent, child, or anyone claiming under them is concerned. Unless there are 3 other competent witnesses to the execution of the will. If A, B, and C are the witnesses to the execution of the will of Mr. X, and in that will, Mr. X gave one of them, Mr. A, one of the witnesses, a legacy of 50 million pesos. The will is valid. The validity of the will is not affected. A remains a qualified witness. Pero sorry na lang siya. He will not be able to get that legacy, even assuming that the estate has sufficient assets. Because under Article 823, that legacy is considered void. The obvious purpose here is to remove any temptation on the part of witnesses who might have been given something under the will to testify falsely. Can you just imagine what would happen? Halimbawa, 3 ang testigo, A, B, and C. Let's assume that we did not have Article 823. And A, one of the 3 witnesses, has been given a legacy of 50 million pesos. Kahit na magluluhod siya sa Quiapo ng 10 taon, hindi niya makukuha yung 50 million na yan. 50 million is 50 million by any mathematics. Now, he is now on the witness stand. Namatay ng testator, maraming assets, and he is being asked the critical question, "Oh, Mr. Witness, where were you in relation to the testator when the testator was signing the will?" Naalala ni A, nandun siya sa loob ng comfort room while the testator was signing the will. Because right before the testator started to sign, nakaramdam si A ng very urgent call of Mother Nature. So he had to rush to the comfort room. And while the testator was signing the will and all the pages thereof, Mr. A was inside, sweating it out, inside the comfort room. When he returned, tapos na, nakapirma ng testator. So, that means the testator did not sign the will in the presence of Mr. A. If that fact can be established, that is not a valid will. The will be disallowed. If the will is disallowed, Mr. A will not get the legacy of 50 million. Siyempre, if the will is void, the legacies under that will are also void. Cannot be given effect. Eh, nandito si Mr. A. He has just taken the oath to tell the truth, the whole truth, and nothing but the truth. Eh, pero naalala niya, if the will is disallowed, hindi niya makukuha yung 50 million niya under the will. If we did not have Article 823, chances are, sasabihin ni A, I was right there in front of the testator when he was signing the will. Magsisinungaling yan. Let's be honest with each other. I do not think that there is any single soul in this room or in the other rooms watching my lecture who will not testify falsely under the same circumstances. Siyempre, sisinungaling ka na dyan. With Article 823, the law is in effect telling the witnesses, magsabi ka na ng totoo. Kasi hindi mo din naman makukuha yan eh. Okay? Might as well tell the truth. Because that legacy is void insofar as you are concerned. If there are 3 other witnesses aside from you swerte ka. The legacy will be valid. You'll be able to get it. Because the allowance of the will not really hinge upon you or depend upon you. There are 3 other competent witnesses. Supposing that instead of being given a legacy or devise, one of the instrumental witnesses, one of the 3, is instead instituted as an heir. Ang sabi ni X sa kanyang will, I give Mr. A 1/8 of my estate. A is one of the 3 witnesses. Will A be able to get 1/8 of the estate? I submit that he will not. Although the law mentions only legacy or devise, there is really no reason why it should not likewise apply, why Article 823 should not likewise apply to a person who is instituted as an heir. There would just the same be the temptation to testify falsely because he would have an economic interest in the allowance of the will. The enumeration of the persons in Article 823 is exclusive. So, sino lang dyan? Yung witness, his spouse, his parent, or child. If instead his grandfather was the one given a legacy or devise, that should be considered valid. Hanggang parent lang or hanggang child. Okay? Alright. Codicils and Incorporation by reference. Tanda lang natin, ano yung codicil na yan? It is a supplement or addition to a will, whereby the provisions in an earlier will are added to, or modified, or altered, or explained. You only make a codicil if you already have a will. The execution of a codicil presupposes that there is a previously existing will, which you then supplement, alter, modify, or explain through your codicil. Formalities, same formalities as in the case of wills. You can therefore make either a notarial codicil or a holographic codicil. If the will which you want to alter, supplement, or modify is notarial, it does not necessarily follow that the codicil should also be notarial. A notarial will can be modified by a holographic codicil. And a holographic will can be altered, modified by notarial codicil. Okay? On incorporation by reference, ano itong incorporation by reference na ito? This is merely for the convenience of the testator. Lalo na yung sangkatutak ang mga pag-aari, sandamakmak ang pag-aari. They don't, if they have already existing lists of properties, descriptions of their properties or inventories, they don't have to actually reproduce these long lists and inventories in their last wills and testaments. They can simply incorporate them by reference under the provisions of Article 827. Remember the requisites for a valid incorporation by reference. Number 1, the paper or document to be incorporated by reference must already be in existence at the time of the execution of the will. Second, the will must clearly describe the paper or document, stating among other things the number of pages thereof. Third, it must be established by clear and satisfactory evidence as the paper or document referred to in the will. Fourth, the paper or document must be signed by the testator and the witnesses on each and every page, except in the case of voluminous books of accounts and inventories. Because of the requirement that each page of the paper or document to be incorporated by reference must be signed by the testator and the witnesses, the question has arisen. Can there be incorporation by reference in a holographic will? Sabi ng iba, walang incorporation by reference in a holographic will because there are no witnesses in a holographic will. Sabi naman ng iba, paano kung may witness? It's possible for a holographic will to have witnesses. The presence of witnesses in a holographic will does not invalidate the will. That is simply considered as surplusage. Supposing there are witnesses. So according to them, if there are witnesses to a holographic will, then it's possible to incorporate by reference in that holographic will. Still others maintain while it is possible to have incorporation by reference in a holographic will, it is necessary that the paper or document should also be entirely in the handwriting of the testator. Because if what is incorporated by reference in a holographic will is a paper or document which is not in the handwriting of the testator, upon incorporation, to borrow the language of Article 827, that paper or document will be taken as part of the will, will be considered as part of the will. And if it is considered as part of the will, and yet it is not in the handwriting of the testator, that may affect even the validity of the holographic will itself. At any rate, that's one of the open questions, disputed points in succession, in testamentary succession. Now, I said earlier that 827 is merely for the convenience of the testator. 827, incorporation by reference, should never, ever be used for the purpose of incorporating testamentary provisions. Testamentary provisions must always be contained in the will itself. Hindi pwedeng nasa ka separate piece of paper and then you simply incorporate this by reference. That's not, those will not be valid testamentary provisions. Example, one day, wala ka masyadong magawa, no, you decided to type on several sheets of paper testamentary provisions which you intend to include in your will. 10 years later, you decide to finally make your will. So you went to your lawyer. Attorney, I want to make a will. O sige, okay. Anong provision? Sabi mo, hindi. Ito na. Na-type ko na ito 10 years ago pa. Ito ang mga provision na gusto ko. O sabi ng abogado, o sige, let's just incorporate this by reference. That's not a valid incorporation by reference. Those provisions are invalid. Because when it comes to testamentary provisions, they must be contained in the will itself. Hindi pwedeng you simply incorporate them by reference. Let's now talk about revocation of wills. The right to revoke a will is one of the basic prerogatives of a testator. A will is essentially revocable, ambulatory in character. As long as the testator lives, he can revoke his will anytime, and he does not even need any reason for revoking his will. All that is necessary is that he wills it, he intends, and he actually revokes his will. There are various ways of revoking a will. First, by implication of law, meaning to say, by operation of law. Second, by executing another will or codicil, or other writing executed as in the case of wills. Third, through a physical act of destruction coupled with intent to revoke, with animus revocandi. And the law specifies the physical acts of destruction. There are only 4: burning, tearing, canceling, obliterating. The enumeration, according to most commentators, is exclusive. By implication of law. You find these instances scattered in the provisions of the Civil Code and of the Family Code. For example, in case of legal separation, the provisions in the will of the innocent spouse in favor of the guilty spouse are revoked by operation of law. The reverse is not true. The provisions in the will of the guilty spouse in favor of the innocent spouse are not revoked. Only the provisions in the will of the innocent spouse in favor of the guilty spouse are revoked by operation of law. Under Article 854, in case of preterition, what is revoked there? The institution of heirs. If there is preterition brought about by the omission, by the complete omission of one, some, or all of the compulsory heirs in the direct line, that results in the annulment of the institution of heirs. In case of a legacy of a credit or remission of a debt, if there is a legacy of a credit or remission of a debt, and the testator brings an action against the debtor, that results in the revocation of the legacy of credit or remission of a debt. In case of transformation, alienation, or loss of the thing, under Article 957, that results in the legacy or devise becoming ineffective. In case there is unworthiness, under Article 1032, okay, the unworthy heir cannot inherit. The provisions in his favor are rendered ineffective. When both spouses contract the marriage in bad faith, under Article 44 of the Family Code, or if the marriage is declared void ab initio or is annulled, under Article 50 of the same Family Code. These are instances of legal provisions which operate to revoke or render ineffective certain testamentary provisions. By another will, if you execute another will expressly revoking a previous will, then that previous will is revoked. Or if there are inconsistencies between an earlier will and a subsequent will, then there is implied revocation. And then, of course, by the physical acts of destruction, burning, tearing, canceling, obliterating. There must always be the corresponding intent to revoke. A physical act of destruction without a corresponding intention to revoke will not produce a valid revocation. Conversely, not all of the intention without the corresponding physical act of destruction will produce a valid revocation. If the testator, for example, fuming mad and so angry with his heir, calls his neighbors and says, I am, as of this moment, revoking this will. This is no longer my will. My heir will not inherit under this will. I am revoking this. And then he suddenly collapses. He suffers a massive heart attack. There is no valid revocation in that case. He might have intended to revoke. But intention must always be coupled with the physical act of destruction, of burning, tearing, canceling, obliterating. If the testator, with all due solemnity, gathers his friends and neighbors and says, I am revoking this will, this is no longer a valid will. Patay na ito. Ililibing natin ngayon. And he digs a hole and buries that will with all due solemnity. Is there a valid revocation? There is none. There is no physical act of destruction. Burying is not one of the acts mentioned. Although in one case decided the Supreme Court, I must hasten to add, the court considered the act of crumpling the will and throwing it as sufficient to produce a revocation. But civilists are more or less agreed. The enumeration here is really exclusive. To revoke a will by burning, you don't have to completely burn the will. Even if only the edges are burned in such a way that not a single word of the will was affected by the fire, hanggang edges lang ang nasunog, that is already considered as sufficient to revoke. When it comes to tearing, the slightest tear is sufficient as long as it is coupled with the necessary intent to revoke. Even if the tear extended only up to the margins, not a single word was affected by the tearing, that will already produce a valid revocation. Of course, instead of tearing, medyo high-tech ka, you can use a paper shredder. Revocation din yan. Or you can use a pair of scissors. That will also produce a valid revocation. Canceling. How do you revoke a will by canceling? By crossing out the lines. How does cancellation differ from obliteration? In obliteration, the words can no longer be read. Binubura. In cancellation, they're simply crossed out. Whatever kind of line you may use. Crisscrosses, spirals, whatever. As a matter of fact, one of the simplest ways of revoking a will through cancellation is by crossing out, cancelling the signature of the testator at the end of the will. If you are the testator and with intent to revoke your will, you cancel your signature at the end of the will. In a very real sense, you strike at the heart of the will. That will operate to revoke the entire will. In connection with revocation, it is entirely possible that the testator may have made several copies of his will. If he wants to revoke his will, does he have to retrieve all copies? The answer is no. He can simply burn or tear the copy which he has. That will produce a revocation of his will. He does not have to retrieve all of the existing copies of the will. Another rule we have to remember in connection with revocation is the doctrine of dependent relative revocation. If the testator revokes a will with the present intention of making a new one immediately and as a substitute, and he is unable to make the new will, or if he is able to make the new will, the same fails to take effect for any reason or cause, it is presumed in the absence of evidence to the contrary that the testator would have preferred his old will to intestacy. In other words, when the testator revokes his will under this doctrine, he does so conditionally. Ano ang condition? That a new will be effective. So kung hindi siya nakagawa ng bagong will, or if the new will fails to take effect, then it is presumed he would rather die with his old will than to die intestate. The best illustration, of course, would be the case of Molo versus Molo. It's an old case. But up to now, that's still the best illustration of this doctrine. Here was a man. He made a first will in 1918. In that will, he gave practically the entire estate to his wife. In 1939, he made another will. In this second will, he expressly revoked his earlier 1918 will. And then again, he gave, ganon naman, just like before, he gave the bulk of his estate to his wife. Namatay. So, pagkamatay niya, the wife presented the second will, yung 1939 will, for probate. Unfortunately, it was disallowed by the probate court. Reason? It failed to comply with the formalities prescribed by law. So, ang ginawa ng widow, ay hindi pala pwede yung 1939 will, balik sa husgado. O ito na lang ang i-probate natin, yung 1918 will. She could not, however, present the original copy of the 1918 will. The best that she could produce was a duplicate of that 1918 will. So the oppositors were saying, nasaan ang original niyan? Kaya hindi mo maipresenta ang original niyan. It's because your husband already destroyed the original copy of that 1918 will. He revoked that by destroying the original copy. Kaya hindi mo na maipresenta ngayon ang original. Okay. Nakarating Supreme Court. Pagdating Supreme Court, ang sabi ng Supreme Court, even assuming that that is true, that the husband, after he made his 1939 will, nung nakagawa na siya ng second will, sinunog na niya yung original nung 1918 will with intent to revoke the 1918 will. Nonetheless, under the doctrine of dependent relative revocation, it is presumed that the revocation of the 1918 will was conditional in the sense that it was conditioned upon the effectivity of the 1939 will. Since the 1939 will failed to take effect, it is presumed that the husband would have preferred his old 1918 will to intestacy. That is the doctrine of dependent relative revocation. Will the doctrine of dependent relative revocation apply to both express and implied revocations? Meaning to say, if there are two wills, there is a second will expressly revoking the first. That implies that the second will, where the express revocation is contained, is a valid will. Therefore, there is no room for the application of the doctrine of implied revocation. Upon the other hand, if there is merely implied revocation, then that also implies that you have two valid wills. the provisions of which are inconsistent with each other, that also necessarily implies that both wills are valid. Otherwise, if the second will is not valid, then you don't even talk of an implied revocation. The doctrine would more specifically apply to revocations effected through physical acts of destruction, coupled with intent to revoke. Because if you're talking of revocation effected through another will, that necessarily implies that the second will is a valid will. But the basis of the doctrine of dependent relative revocation is that the revocation is dependent upon the validity of the second will or the ability to make a second will. So, that's how it should be applied. Another point which I want you to remember in connection with revocation is this. Sometimes revocation may be presumed, depending sa circumstances. For example, there is evidence to the effect that the will was in the possession of the testator. He is the one in possession of the will. After the death of the testator, the will is found among his possessions, among his effects, in a tattered and torn condition. The presumption is that the testator revoked his will. Or if after his death, the will could not be found, and the evidence is clear that he was the one in possession of it, it may be presumed that the testator revoked his will. You also remember the provisions of Article 833. A revocation based on a false or illegal cause is not valid. The important thing I want you to remember, however, is that before you can invoke Article 833, it is necessary that the cause for the revocation must be stated in the will. If the testator simply revokes a will, even assuming that the cause for the revocation is false or illegal, but he did not state the cause for the revocation in the will itself, there will be no basis for any invocation of Article 833. You of course remember that even if a will is revoked, any recognition of an illegitimate child contained in that will is not affected. Because a recognition of an illegitimate child is not really in the nature of a testamentary disposition, which is subject to the sole will of the testator. A recognition creates a status, and there must be a certain element of stability insofar as the status of individuals is concerned. Okay. Going now to republication and revival, you remember the difference between the two. Republication is brought about by the act of the testator. Revival is brought about by the law. Remember the two ways of republishing a will. First, you can republish a will by simply executing a codicil to that will. If you do that, the will is republished as modified by the codicil. You can also republish the provisions contained in a previous will by reproducing those provisions in a subsequent will. As a matter of fact, if the previous will is void as to form, the only way of republishing the provisions contained in that will is by copying the provisions in that will in a new will. You cannot republish the provisions contained in a will which is void as to form by simply executing a codicil to that will. What is the effect of republication? A will which is republished by a codicil speaks as of the date of the codicil. In other words, it is as if the will was made at the time of the execution of the codicil. And that may have some legal consequences. Let me explain. Let's assume that the testator made a will in 1985. He makes another will in 1990. Let us further assume that the provisions of these two wills are inconsistent with each other. irreconcilable. If the testator dies with these two wills, which will be given effect? Of course, there is no choice. It's the 1990 will, because it is the later expression of the testator's intent. Siyempre, in case of irreconcilable conflict. All right. Let us assume, however, that in 1992, the testator made a codicil. In this codicil, he said, I hereby modify the following provisions in my 1985 will. So the codicil was made referring to the 1985 will, modifying some provisions of that will. What is the effect? The mere execution of the 1992 codicil will have the effect of republishing the 1985 will as modified by the codicil. This means that it is as if the 1985 will was actually made in 1992. Yun ang effect ng republication. Now, assuming there are still irreconcilable conflicts between the provisions of this will and the provisions of the 1990 will, which will now be given effect? Yung 1985 will na. Because it is as if it is the latest expression of the testator's will due to republication. It is as if this will, as modified by the 1992 codicil, was actually made in 1992. Therefore, it would be later than the 1990 will. Remember, however, that republication through a codicil is not possible if the earlier will is void because of form. Hindi pwede ang republication through a mere codicil. If the 1985 will is void because of failure to comply with formalities, the provisions in this will can only be republished by copying them in a subsequent will or codicil. If the testator made his 1985 will, in this case, when he was only 16 years old, and then in 1992, he makes a codicil to the 1985 will. Will the 1985 will be republished? The answer is yes. Because it is not defective, it is not void as to form. The problem is with respect to the capacity. But when the codicil was made, he was already fully capacitated to make a will. So there is a valid republication. Pero kung ang defect is with respect to form, halimbawa, 1985 will, notarial in character, walang attestation clause or defective attestation clause, it is not possible to republish that through a codicil. Kung gusto mong i-republish ang provisions, you'll have to reproduce those provisions in a subsequent will. When it comes to revival, isa lang naman ang provision dyan, yung Article 837. The only thing you ask yourself is this: how was the first will revoked by the second will? If a first will is expressly revoked by a second will, forget about revival. Even if the second will is itself revoked by a third will, the first will not be revived. If, however, a first will is merely impliedly revoked by a second will, implied revocation, yung inconsistent lang ang provisions, then, the moment the second will is revoked by a third will, the first will be revived. So, isa lang ang tanong sa revival. How was the first will revoked by the second will? If the first will was revoked expressly by the second will, forget about revival. Hindi posible ma-revive yan. If the first will, however, was merely impliedly revoked by the second will, then revival is possible. If the second will is itself revoked by a third will, the first will, which after all was merely impliedly revoked by the second will, that will be revived. Allowance and disallowance of wills. There are some important points which I want to emphasize in connection with allowance and disallowance. Number one, probate is mandatory. As long as a person dies leaving a will, the probate of that will is mandatory. An unprobated will does not produce any effect. Why is probate mandatory? It's a matter of public policy, designed to protect not only the interest of the heirs and other beneficiaries under the will, but also to protect the interest of the testator. Because if probate is not mandatory, nobody will bother to make a will anymore. After all, when you die, your relatives can simply disregard your will, and you will not be in any position to protest or object. You'll be 6 feet below the ground. So, the making of a will would be completely an exercise in futility, to use a trite expression. Probate is imprescriptible. There is no time limit for the institution of probate proceedings, because the law itself mandates that probate is mandatory. It's a matter of public policy, and therefore, the same law could not have set any time limit for the probate. Otherwise, that public policy would be defeated. Third point, there are only 3 matters which can be properly inquired into during the probate proceeding proper. So, in a settlement case, if there is a will, the first part would deal with the probate of the will. Okay, probate proper. Okay, publication, and filed petition, publication, etc. So, the first part would be the probate proper. That's the time when the law, when the court would look into the question of whether or not there is a valid will. At that point, during the probate proper, only 3 things can be properly inquired into by the probate court. What are these 3 things? Capacity, identity, and due execution. Yun lang 3 bagay na yun ang pwedeng pag-usapan during the probate proper. Did the testator possess the necessary capacity when he made the will? Is this document really the last will and testament of the testator? Third, were the formalities prescribed by law for the valid execution of a will followed in the execution of this will? Only those three questions can be properly addressed by the probate court during the probate proper. At that point, it is not proper for the probate court to inquire into the intrinsic validity of testamentary provisions. Hindi pa pwedeng pagtalunan at that point. Oh, is this provision valid? No, not yet. That will come later on. So, only those 3 things. Under exceptional circumstances, however, the Supreme Court has allowed a departure from that general rule. When would that be? Where it is clear that a testamentary provision is clearly void and that a probate would be a waste of time because the only provision in the will happens to be void. In that case, the court can inquire into the intrinsic validity of that provision. The best example would be Nugid versus Nugid. There was a very simple will. The testatrix in that will gave to one of her siblings her entire estate. Yun lang ang provision. A sibling was instituted as heir. The parents of the testatrix were still alive. They were not mentioned in the will. Nothing was given to them. They were clearly preterited. Sabi ng Supreme Court, it is useless to go ahead with the probate of this will because it's already clear that the only provision in that will is not effective because of preterition. Eh bakit pa tayo magsasayang ng oras? Okay? So you might as well decide on the basis of what appears on the face of the will whether or not that provision on institution is valid. That would be the exception. Another good illustration would be the case of Nepomuceno versus Court of Appeals. Here was a man very much married. Problema sa kanya, meron siyang kabit. During the probate proper, the order of the court for the probate of the will was appealed to the Court of Appeals. The Court of Appeals said, the will is valid. But, sabi ng Court of Appeals, these provisions in favor of the mistress are void. So, the mistress went up to the Supreme Court. Sabi ng mistress, the Court of Appeals committed an error. Mali. Kasi probate pa lang ito, hindi pa dapat pinag-uusapan at this point yung intrinsic validity ng provisions in my favor. Ano sabi ng Supreme Court? The Court of Appeals did not commit any error. Because it's plain upon the face of the will that the provisions in favor of the widow, of the mistress rather, are null and void. You cannot donate, di ba? You cannot donate under Article 739 to people with whom you are guilty of adultery or concubinage. And that prohibition under Article 739 of the Law on Donations has been incorporated by reference in the Law on Testamentary Dispositions. So, that would be a good example of the application of the exception. Probate may be post-mortem or ante-mortem, either during the lifetime of the testator or after his death. Of course, there are certain advantages and disadvantages. If you probate your will during your lifetime, well, the advantage there is that if there are any defects in the will, you are still alive. You can still correct those defects. You can make another will if the will you had earlier made turns out to be invalid. Okay? Ang disadvantage niyan, there is premature disclosure of the testamentary dispositions. So, yung mga kamag-anak mo, malalaman na kung ano ang laman ng last will and testament mo. Alright. Remember that once a will has been allowed, the allowance of the will has attained the character of finality. That is conclusive as to its due execution. Ibig sabihin, hindi na pwedeng pagtalunan later on, whether or not the will is valid, whether it's a forgery or whatever. Conclusive na yon. That's finally settled. That is the reason why in one case, I refer to Mercado versus Santos, classic illustration of the application of this principle. There was a woman, a wife, she died. Her husband presented her will for probate. It was allowed by the probate court. Allowed. Valid will, sabi ng probate court. 16 months later, 16 months later, the relatives of the wife, nung namatay, instituted criminal proceedings against the husband. Sabi nila, he is guilty of falsification. He forged the will of his wife. Sabi ng Supreme Court, it's too late in the day. Hindi na pwede yan. Because the probate of the will is conclusive as to its due execution. And when you say due execution, of course, that necessarily includes the authenticity of all of the signatures appearing in that will. So, hindi na pwede. Next point. The provisions of a will cannot be subject of a compromise agreement. Court made that clear in Rabadilla versus Court of Appeals. Why? Because the will is the expression of the intention of the testator as to the manner in which he wants his properties to be disposed of. His wishes must therefore be strictly followed. If a compromise agreement will be allowed, providing for a different manner of division, that will defeat the purpose of making a will. Eh para kaya naggawa ka pa ng last will, kung pwede naman palang i-disregard yan through a compromise agreement. The grounds for disallowance of a will under Article 839 are exclusive. There are no other grounds aside from those mentioned in Article 839. For example, failure to comply with formalities, there was violence, force, there was undue influence. In connection with undue influence, yung violence, intimidation, madaling maintindihan yan. Okay? Intimidation, natutukan ka, you are threatened with serious bodily harm, okay? Or harm to your property. Undue influence. When is there undue influence? You will notice that undue influence is also a cause for vitiation of consent in contracts. It's a ground for disallowance of a will. But if you look at the cases decided by the Supreme Court, it's very difficult to find a case where the court found that there was in fact undue influence. In succession, as far as I know, there is only one case where the Supreme Court said there was undue influence. I refer to the case of Revilla versus Court of Appeals. Why is that so? Because, you know, as I always tell my students, man is a social being. We do not live in isolation from each other. We live with our families. We interact on a daily basis with our friends, our classmates, our office mates. We interact on a daily basis with other people. And as a result of this daily, constant interaction with other people, it cannot be avoided. We are bound to influence other people in the same way that other people are bound to exercise some measure or degree of influence over us. Hindi ma-avoid yan. But as long as the influence does not overpower our will, as long as our will is not subjugated by the will of another, as long as we are still able to express our own will, to manifest our own will, make our own decisions, there is no undue influence. A father has 4 children, A, B, C, D. After his death, it is discovered that in his will, he gave A, B, and C only their legitimes. He gave the rest of the estate to his youngest, D. The distribution is obviously unequal. Does that fact, will the mere inequality of distribution by itself prove undue influence? The answer is no. No, unless the Supreme Court has said so in Icasiano. Mere inequality of distribution does not prove by itself that there was undue influence. Why? Because the principal reason people make wills is precisely because they do not want their legal heirs to inherit equally. If you are a parent, you want your children to inherit equally, why bother make a will? You might as well die intestate. Because under the rules of intestacy, if you die without a will, your children will inherit equally. So the precise reason why people make wills is precisely because they do not want their legal heirs to inherit equally. So mere inequality does not prove, inequality of distribution does not by itself prove undue influence. Let's go on with that sample. Supposing that it can be proved through the testimony of nosy neighbors that the testator in that case made his will when he was living with his youngest son, D. Doon siya nakatira sa bahay ni D. There is even testimony to the effect that the neighbors would constantly hear D pleading with his father to give him more than his brothers. Dad, you give me more than my brothers. Kasi sa lahat ng anak mo naman, alam mo, tayong dalawang magkamukha. Binubulan niya yung tatay niya. Okay? May ebidensya dyan. Ganyan. Will that establish undue influence? No. As long as there is no evidence which would show that the father lost his freedom of choice. The father was still free. So there is no undue influence. Let us take, however, the case of Revilla versus Court of Appeals. Here was an old man, Don Cayetano Revilla. He was the owner of valuable pieces of real estate here in Manila. He was not married, matandang binata. And his closest relatives were his 9 nephews and nieces. These nephews and nieces were all full-blood brothers and sisters. Magkakapatid to. So, si Don Cayetano, merong isang kapatid na nagkameron ng 9 na anak. So, yung 9 na anak ng kapatid niya, who was already dead, these were his closest relatives. Don Cayetano made a will. That will was presented for probate during his lifetime. Ante-mortem probate. In that will, everything was divided fair and square. Ang sabi niya sa kanyang will, I give each of my nephews and nieces, siyam yun ha, I give each of them as heir 1/10 of my estate. So bawat isang pamangkin, 1/10 ang binigay ni Don Cayetano. With respect to that other 1/10, that will be used for the upkeep and maintenance of the chapel which I have, I think somewhere in Bulacan. So, presented for probate, allowed during his lifetime. After his death, the eldest nephew suddenly came out with a supposed second will. Sabi niya, wala na yung earlier will na yan. Ito na ang will ng tiyo namin. And lo and behold, in that second will, supposed second will of Don Cayetano, the old man supposedly gave the eldest nephew everything. Walang binigay doon sa mga kapatid niya, pati yung 1/10 para sa taas napunta sa kanya. Sabi niya, ito na ang will. It was established, however, that at a certain point, that eldest nephew was able to take full control over Don Cayetano. There was a point when he isolated the old man from all of his brothers and sisters. He took him to a certain residence where his brothers and sisters couldn't visit the old man. At a certain point, I think they even had to secure a court order to visit him. The case ultimately reached the Supreme Court. Ang sabi ng court, here is a case where there was undue influence. And that undue influence, the total control which he had over the old man, was in turn used by that eldest nephew to foist the fraud upon the old man, to make him sign that supposed second will without the old man realizing that it was supposed to be another last will and testament. Next point. There is that other humorous case where a will was disallowed. Ang tawag ko dito sa kaso ito, kaso ng katangahan. Okay? I refer to Calde versus Court of Appeals. A will was presented for probate. Of course, when a will is presented for probate, you expect the 3 witnesses to be called to testify. All 3 witnesses, when called to testify on the witness stand, were asked an identical question. Mr. Witness, how many pens were used in signing the will? All 3, one after the other, all answered, just one, Your Honor. The will was disallowed. Bakit? Looking at the will, kitang-kita mo iba-iba ang tinta nung na pinampirma doon sa will. Hindi ba naman katangahan yun? Okay? What was the net consequence? The court said, those 3 witnesses were not really present when the will was signed. Otherwise, they would have known that more than one pen was used. Net consequence, the will was disallowed. There is a question, will the recognition of an illegitimate child stated in a will still be effective when said will is disallowed? Well, it would depend upon the reason for the disallowance. If, for example, the will is disallowed because it's proved that it's a complete forgery, it's not really, it was not really executed by the supposed testator, then I do not think that recognition can be given any effect. It's not the recognition effected by the testator himself. But if it is, after all, the authentically signed recognition made by a person, you can consider the will as an authentic document instead of considering it as a last will and testament. There are various ways of effecting a recognition. Let's now go to institution of heirs. You can have a valid will even if nobody is instituted as an heir in that will. In other words, pwede naman na you make a will, you simply give out your properties through legacies and devises. Pwede yun. But of course, it's always better to institute somebody as an heir, especially to the net remainder of your estate, because you can never anticipate what your properties will be at the time you die. Kasi when you make a will, hindi naman ibig sabihin, I make my will today, bukas patay na ako. Hindi, it may take you another 20, 30 years before you finally kick the bucket. Sabi nga. In the meantime, you'll be acquiring other properties. So, you could not possibly foresee exactly what properties you'll be acquiring later on. Kaya that's the advantage of instituting somebody as an heir. Otherwise, there is the very great possibility that many of your properties will actually pass to your legal heirs through intestate succession. To have a valid institution of heirs, it is not really essential that you include the complete name and surname of the heir. Okay? Ang rule of thumb lang dyan is, as long as it is possible to determine the identity of the heir by some event or circumstance, that would be a valid institution. I give the entire free portion of my estate to the incumbent president of San Sebastian College at the time of my death. Oy, sino yun? Hindi ko alam. Okay? But there is an event or circumstance by which the identity may become known. So whoever is the incumbent president of San Sebastian College at the time of the death will get the entire free portion of my estate. But supposing that the institution is so malabo, I give one half of my estate to some Sebastianians. Sino yun? Sino yung some na yun? Okay? Or I give some 1/4 of my estate to some Barribuis. Super labo yan. That is considered as a disposition in favor of an unknown person. Pag merong ganon, the disposition is void. And the properties given to these unknown persons will instead be merged with the mass of the estate and given to the legal or intestate heirs of the testator. You remember, however, that under Article 786, which we had earlier discussed, the testator can make a disposition, leave a specific property or sums of money in favor of a class or a cause. Pwede yan. I leave 50 million for the charitable institutions in Metro Manila. Pwede yan. I give 10 million for the street children of the city of Manila. Pwede yan. That's a disposition in favor of a class. Remember the rule of equal division under Article 846. Heirs instituted without designation of shares will inherit equally. Remember, however, that the legitimate should always be protected. Let's assume that X is the testator. He says in his will, I hereby institute A, B, and C as my heirs. X does not have any, let's assume, does not have any compulsory heirs. The estate is 120,000 pesos. So how do we distribute? Since A, B, and C have been instituted as heirs without designation of shares, we apply the rule of equal division in Article 846. They will inherit equally. So, 40, 40, 40. Supposing that A is actually a legitimate child of the testator. In that case, do not make the mistake of applying Article 846 directly, because if you do that, that will result in the impairment of the legitimate of A. A, as a compulsory heir, a legitimate child, is entitled to 1/2 of the estate, 60. What do you do with the other 60, the free portion? That's where you apply the rule of equal division. So A will get 20 as a voluntary heir, B 20 as an instituted heir, and C another 20,000 as an instituted heir. If a person institutes A, B, C, and the children of D, and D happens to have 3 children, E, F, and G. So, ang sabi niya, I institute A, B, C, and the children of D. The heirs collectively designated are considered individually instituted. Ibig sabihin, you divide 120 by 1, 2, 3, 4, 5, 6. 1/6 for each of them. Because although E, F, G have been collectively designated, ang sabi lang, children of D, they are deemed individually instituted. Let us assume that the testator this time says, I institute A, B, C, and D as my heirs. But A will get 1/2 and B will get 1/4 of my estate. How do we distribute 120,000? Since he specified the share of A, then we follow that. So A should get 60,000. He also specified the share of B, 1/4. So B should get 30,000. We apply 846, rule of equal division, to the remainder. So the remaining 30,000 will go to C and D in the amounts of 15,000 pesos each. Supposing that the testator says, I institute A, B, C, D as my heirs, but A will get 1/2, B will get 1/4, and C will get 1/4. He did not specify the share of D. How do we distribute? In this case, again, we follow what was specifically stated in the will. A gets 1/2, 60. B gets 1/4, 30. C gets another 1/4, 30. And D gets 0. Pasensya siya. It turns out na parang binola lang siya when he was instituted. Because when the testator specified the shares of A, B, and C, it already covered the entire estate. Nothing is left for Mr. D. If the testator says in his will, I hereby give A 1/2 of my estate. I give B 1/4 of my estate. The estate is 120,000. How do we distribute? Then we follow the will. Sinabi niya, A is given 1/2, so we give A 60,000. Sinabi niya, B is given 1/4, we give B 1/4, 30,000. May sobra pang 30,000. To whom should this go? It should go to the legal heirs of the testator. Okay? If the testator, in instituting the heirs, stated their fractional parts, and the fractional parts together do not cover the entire estate, then the part not disposed of by will should go to the legal or intestate heirs. It is different if there is a clear intention to give the entire estate to the instituted heirs, but the fractional parts do not seem to cover the entire estate. That is the time when you go into a proportional increase. Okay? So, kung ang sinabi niya dito sa kanyang will, I give my entire estate to A and B, but A will get 1/2 and B will get 1/4, that's a very clear indication that his intention is to give the entire estate to A and B. The only problem is that medyo nakalimutan niya ang kanyang fractions. Kala niya yung 1/2 plus 1/4 will already cover the entire estate. This is where you go into a proportional increase. Yung proportional decrease naman, baliktad. Napasobra. A is given 1/2, B is given another 1/2, and C is given 1/4. Sobra-sobra yun. So, in that case, you go into a proportional decrease, okay, of the shares given to the heirs. All right. Ang isa sa pinaka-importante rito, if not the most important item here in institution, would of course be yung Article 854, yung tinatawag na preterition. When is there preterition? There is preterition if a compulsory heir in the direct line is completely omitted in the will, and nothing has been given to him by the testator by gratuitous title, even during his lifetime. All right. What is the purpose of this rule? Why is it that the law says, if there is preterition, kung merong compulsory heir in the direct line who's been omitted, the institution of heirs is annulled? Bakit hindi nilang sinabi ng law, if somebody is omitted, the omitted heir will still get his legitim? Hindi. Ang sinabi ng law, complete annulment of the institution of heirs. The reason is that ang original concept ng preterition is that this is simply due to forgetfulness. Nakalimutan lang ng testator yung compulsory heir who was omitted. Hindi sinadya. And therefore, the law assumes that if the testator had simply remembered that heir, kung naalala lang niya yung heir na yon when he was making the institution of heirs, he would not have made that kind of an institution of heirs. Ang tanong natin is, kung sinadya ang omission, if the omission was done intentionally, can that still be considered as preterition? That question has been answered by the Supreme Court in Ventura versus Ventura. The court said, well, it was a divided division of the court. Ang botohan dyan, 3-2. Sabi ng majority, that is still preterition. What happened in Ventura was something like this. Gregorio Ventura, who must have been deeply in love with his own name, kaya nagkaanak siya, Gregoria ang pinangalan niya sa anak na babae. Meron siya ng 2 children, legitimate by a previous marriage. Later on, si Gregorio at saka yung 2 anak niya sa first marriage, nag-away. So, it reached a point where Gregorio even denied paternity of the 2. The 2, of course, were able to establish their legitimate filiation, the paternity of Gregorio, in a separate case which reached all the way up to the Supreme Court. In the meantime, Gregorio made a will, which he presented for probate during his lifetime. Of course, in that will, he did not give anything to the 2. Tinatanggihan nga niya, hindi ko anak yan. The omission of the 2 was therefore clearly intentional. Sinadya ang omission. Hindi lang basta-basta nakalimutan. It was an intentional omission. Ang tanong dyan is that preterition? Sabi ng Supreme Court in Ventura versus Ventura, that is preterition, even if the omission was done intentionally. Of course, the 2 dissenters in that decision said, that's no longer preterition, sinadya eh. That should be considered imperfect disinheritance. Pero yung majority sabi, that is still preterition. If a compulsory heir in the direct line is mentioned in the will, ang sabi ng testator, with respect to his youngest son, I give my youngest son thee all of my love and affection from here until eternity. That is still preterition, basta walang binigay. Binanggit ka nga, wala nang binigay sa iyo, that is still preterition. The compulsory heir who is omitted must be a compulsory heir in the direct line. If you omit your spouse, kinalimutan mo o sinadya mong walang bigay do sa iyong asawa, that is not preterition. Because your spouse, although a compulsory heir, is not a compulsory heir in the direct line. So, sino ang compulsory heirs in the direct line? When do you say that you belong to the direct line? If you are related to each other as parent or child or as ascendant, descendant. Yun lang, direct line. If the omitted compulsory heir is an adopted child, maliwanag, preterition yan. Because an adopted child has basically the same rights and position in the law as a legitimate child. If the omitted child is an illegitimate child, that is also preterition. Because even illegitimate children are compulsory heirs in the direct line. If there are no children, especially legitimate ones, but the parents are alive, the parents in that case are compulsory heirs. And if they are omitted, again, that is preterition. The omission must be total and complete. And I mean total, as in total. Complete. Wala. Kahit na ano, walang naibigay gratuitously to the omitted heir. If a compulsory heir in the direct line is completely omitted in the will of the testator, but during the lifetime of the testator, he had donated something to that compulsory heir, meron na siyang naibigay doon by way of donation, there is no preterition. For the same reason, if the omitted heir in the will stands to receive something by way of intestate succession, there is no preterition, as we will later on discuss. Walang preterition yun. Kung merong matatanggap as a legal heir. Halimbawa si X, may anak, si A. In his will, he says, I give my friend G 9/10 of my estate. A is not mentioned. Is there preterition? Wala. Why? Anong sabi ng law? If the will does not dispose of the entire estate, what do you do with the part not disposed of by will? You give it to the legal or intestate heirs. Merong undisposed na 1/10. So kahit anong mangyari, may matatanggap pa yan si A. That prevents preterition. Okay? Of course, A will be entitled not just to 1/10. He'll be entitled to the completion of his legitim. Okay? All right. But that's not preterition. Yun ang punto ko. In that case, you apply the provisions of Article 855 of the Civil Code. Supposing that in this case, ang sabi ni X is, I give A by way of legacy 5,000 pesos. I give the rest of my estate to G as my heir. Is there preterition? Wala. Because the omission is again not total and complete. May 5,000 legacy na binigay. So that prevents preterition. Of course, A is entitled not just to 5,000 but to his legitim, okay, which is 1/2 of the estate. But the point is that the omission is not total and complete. Therefore, there is no preterition. All right. What is the effect of preterition? Sabi natin, it will annul the institution of heirs, but legacies and devises will be respected insofar as they are not in officious. So let's use the same example we used earlier. X dies with a will. In that will, there are only two provisions. Sabi niya, I give my friend F 10,000 pesos. I give the rest of my estate to my friend G. A is not mentioned. Let's assume that no donations had been made to A during the lifetime of X. A is, of course, a compulsory heir in the direct line. His omission is total and complete. Ergo, this is a clear case of preterition. So, applying Article 854, what will be the effect? The institution of G is annulled. Parang hindi siya in-institute as heir. Annulled. The legacy in favor of F will be respected insofar as it is not in officious. Or when is a legacy considered in officious? If it exceeds the free portion. Legitim of A is 60,000. The free portion is the other 60. Of course, the 10,000 legacy given to F can be contained in the free portion. May sobra pang 50,000, sabi natin, this will go also to Mr. A. G ends up with 0 because his institution as an heir has been annulled by reason of preterition. If the omission is not total and complete, there will be no preterition. If there is no preterition, you don't apply Article 854. Next point. What is the effect of the predecease of the omitted heir? Let's assume that X has two children, A and B. B has a son, C. In the will of Mr. X, he said, I give my entire estate to my son A. B is not mentioned. Nothing has been given to him. B is therefore preterited. Let us assume, however, that B dies ahead of Mr. X. What is the effect of the predecease of the omitted heir insofar as the preterition is concerned? Paragraph 2 of Article 854. If the omitted heir should die ahead of the testator, anong sabi ng law? The institution of heirs shall be effectual without prejudice to the right of representation. Yung phrase na without prejudice to the right of representation, that is subject to two varying interpretations. According to one view, ang ibig lang sabihin niyang without prejudice to the right of representation is that C, the child of B, will be entitled to the legitim. The rest of the estate will go to A. So, legitims here, 1/2 of 120. That yun ang legitim paghatian ni A and C. So, 30,000, the legitim which B would have received, 30,000, would now go to C. The rest of the estate, 90,000, will go to A. That's one view. The other view is that, in this case, there is still preterition, which will annul the institution of heirs. Why? When do you determine a person's compulsory heirs? As of what moment? Sabi ng ditong view na ito, and I think that's correct. applying the basic principle contained in article, ang paborito nating article, 777. The rights to the succession are transmitted from the moment of death of the decedent. We therefore should determine who a person's compulsory heirs are as of what moment? At that moment of death. Because it is at that moment when there is supposed to be a transmission of successional rights. So logically, dapat alamin kung sino ang mga heredero at that moment. O, namatay. O, sino ngayon? Kaninong mapupunta? At the moment of death of X, who were his compulsory heirs? A and C. You don't talk of B anymore. Patay yan eh. At the moment when X dies, his compulsory heirs are A and C. C is a compulsory heir in the direct line. And C himself, hindi na si B ang pinag-usapan, si C. C himself, a compulsory heir in the direct line, has been completely omitted in the will. Therefore, there is preteration of C, which should result in the annulment of the institution of A. The estate will therefore be distributed 60-60, one-half, by intestate succession because of preteration. I submit that's the better view. If there is an omission of a compulsory heir, but the omission does not amount to preteration, you don't apply 854, you apply 855. Unfortunately, Article 855 seems to be one of the more problematic provisions in the Civil Code. This is one of those articles which is the result of faulty codification. Why? Kasi ang sabi lang dito, the share of a child or descendant omitted in a will must first be taken from the part of the estate not disposed of by will. Question, supposing that the omitted compulsory heir is not a child or descendant, what rule are you going to apply if not Article 855? Mali. Dapat, the share of a compulsory heir omitted in a will must first be taken, hindi lang child or descendant. Kung basta compulsory heir omitted in the will, must first be taken from the part of the estate not disposed of by will. Now, if that is not sufficient, so much as may be necessary under the article shall be taken proportionally from the shares of the other compulsory heirs. Aba, bakit yung compulsory heirs lang ang pagbabawasan mo? Supposing there are voluntary heirs together with the compulsory heirs who have been instituted by the testator. If there is anyone who should suffer a reduction, it should be the voluntary heir. Because in the case of the compulsory heirs, they get their legitimes by force of law, not by reason of the will of the testator. In the case of the purely voluntary heirs, they get everything because of the will of the testator. So if there is anyone who should suffer a reduction, it should be the purely voluntary heirs. But I repeat, kung preteration talaga, maliwanag na preteration, you don't apply 855. 854 ang i-apply mo. Simply, you simply annul the institution of heirs. So, tandaan lang, if the omission is not total, that is not preteration. Simply complete the legitime of the omitted heir. But you respect the institution and legacies and devises. If there is preteration, simply annul the institution of heirs, respect legacies and devises, as long as they are not inofficious. And then you remember the basic principle under Article 856. A voluntary heir who dies ahead of the testator transmits nothing to his own heirs. Let's assume that X has no compulsory heirs. And then he says in his will, I give my entire estate to my friend F. And F happens to have two children, A and B. F, however, dies before X. Predeceased, nauna namatay. O what rights, if any, will A and B get? Nothing. Wala. Because F is a purely voluntary heir. He transmits nothing to his own heirs. Sorry na lang kung namatay siya ahead of the testator. Okay? Let's now talk about substitution of heirs. As part of the right of disposition of the testator, sabi natin, testacy is preferred over intestacy. The law, as much as possible, would want to give primacy to the will of the testator. As part of that underlying principle of primacy of the will of the testator, the law allows the testator to designate substitutes. So, testator may institute somebody as an heir, and at the same time, the law allows him the right to designate somebody as substitute. Para man kung may aberya ang mangyari doon sa instituted heir or to the legatee or devisee concerned, somebody will be able to take his place. There are various types of substitution. You have the simple substitution, tao-tao, one-on-one. A is instituted as heir, B is designated as substitute. So, simple substitution. There is the so-called brief substitution. In a brief substitution, there are two or more substitutes for a single heir. So, testator institutes Mr. A as heir and designates B and C as his substitutes. Brief yan. Yung compendious, baliktad. There is one substitute for two or more heirs. Okay? That's compendious. There is also reciprocal substitution. A, B, C are instituted as heirs, and at the same time, the testator says they shall reciprocally be the substitutes of each other. Reciprocal yan. So, any one of them predeceases, repudiates, or becomes incapacitated, the other two will be the substitutes. If the testator does not specify the causes for the substitution, it is understood that substitution will take place in case of RIP, repudiation, incapacity, and predecease. The testator, of course, may specify. If he specifies, then substitution will only take place upon the occurrence of the particular cause specified by the testator. Kung sinabi ng testator, I institute A as my heir, and I designate B as his substitute in case A should predecease, then it is understood that there will be substitution only if A predeceases. If A does not predecease, he instead repudiates, will there be substitution? There will be none. Kasi in-specify ng testator na substitution will take place only in case of predecease. Alright. If there are several heirs, and they are at the same time designated as reciprocally the substitutes of each other, and a vacancy occurs, there is predecease, incapacity, or repudiation. Ang sabi ng Article 863, the substitutes shall have the same share in the substitution as in the institution. That simply means they'll have the same proportional shares. So let's assume that X has no compulsory heirs. Sabi niya, I institute as my heirs A, B, and C, but A will get 1/2, B will get 1/4, and C will get 1/4 of my estate. And at the same time, I designate them reciprocally as the substitutes of each other. Let's assume that the estate is 600,000. 1/2 would go to Mr. A, 300, 1/4 to B, that's 150, 1/4 to C, another 150. Let's assume that B predeceases. So, substitution will now take place. Sabi ng law, they will have the same share in the substitution as in the institution. That means they'll have the same proportional shares. So how do we distribute this 150? The proportion between A and C is, of course, 2:1. 300 is twice as much as 150,000. So, 2/3 of 150 will go to Mr. A. 1/3 of 150 will go to Mr. C. So, this would be equivalent to 50. This will be equivalent to 100,000. That's how they are going to share in the 150,000 share of Mr. B. All right. There is fideikommissary substitution when the testator institutes a first heir known as the fiduciary heir and imposes upon him the absolute obligation to preserve and transmit the properties given to a second heir known as the fideikommissary substitute. Both the first and the second heir must be living at the time of death of the testator, and the substitution should not go beyond 1 degree from the heir originally instituted. The basic concept and basic requirements for a valid fideikommissary substitution are found in Article 863 of the Civil Code. The substitution, the law says, must not go beyond 1 degree from the heir originally instituted. What is meant by 1 degree? The Supreme Court in Ramirez versus Ramirez said that 1 degree means relationship, blood relationship. Therefore, you can only have a fideikommissary substitution if the fideikommissary substitute is either the parent or the child of the fiduciary heir. Because only a parent or a child can satisfy the 1 degree limitation. Under that view, of course, there can be several transfers of the property as long as all of the subsequent transferees are first-degree relatives of the first heir. Halimbawa, first transfer would be to the father of the fiduciary heir. The next transfer would be a son of the fiduciary heir. O, 1 degree pa rin yan from the fiduciary. The next transfer will be the mother of the fiduciary heir. O, 1 degree. The next will be a daughter of the fiduciary. O, 1 degree din yan. There can be several transfers. Let us assume that X has no compulsory heirs. Nasabi niya, I give my entire estate to my friend A as my universal heir. But I order A to preserve all of the properties I'm giving him and to transmit these properties to his son C. Let's assume that C has 2 children, D and E. That would be a fideikommissary substitution. A is the fiduciary heir, C is the fideikommissary substitute. The testator has imposed upon A the absolute obligation to preserve and to transmit the properties intact to a second heir. C is also a first-degree relative of A. Upon the death of X, of course, as provided in his will, all of his properties will go to Mr. A. What is the nature of the right of Mr. A over these properties? Basically, the rights of a mere usufructuary. Pwede niyang gamitin, can gather the fruits, etc. But of course, he cannot alienate, dispose. For how long will A hold these properties? If the testator is specified, the period, that should be followed. If the testator says, for example, that A will hold the properties only for 5 years, and after 5 years, they shall be transmitted to C, then that should be followed. If the testator did not specify the transmission, the time of transmission would depend upon Mr. A. Nasa kanya na yun. After holding for only 2 years, gusto niyang i-transmit. Okay lang, walang problema. It all depends upon him. The longest period, of course, that A can hold these properties would only be up to the time of his death. Pag namatay na siya, of course, transferred na yan sa fideikommissary substitute. Supposing that C should die in 1995. A finally dies 1998. In other words, C, the fiduciary heir, died ahead of the fiduciary heir. What will now happen? Simple. The rights of C would now pertain to D and E. As long, of course, as both A and C were alive when X died. Because remember, in a fiduciary substitution, it is expressly required in Article 863 that both the first and the second heir should be alive at the time of death of the testator. Why? Because in a fiduciary substitution, both the first and the second heir inherit directly from the testator. Never make the mistake of thinking that the second heir inherits from the first heir. No, that's wrong. The second heir inherits directly from the testator. And when does the second heir inherit from the testator? From the moment of death of the testator, when successional rights are transmitted. So even if the second heir, the fiduciary substitute, dies ahead of the first heir, that's not a problem because the second heir actually acquires rights from the moment of death of the testator, and he is able to transmit them to his own heirs. That's very clear, by the way, in Article 866 of the Civil Code. All right. A fiduciary substitution, please take note, cannot, of course, burden the legitimate. If the first heir happens to be a compulsory heir, a fiduciary substitution can only be established with respect to his share of the free portion. Pagdating do sa kanyang legitim, hindi pwedeng subject to a fiduciary substitution yan. Why? Because the legitim is something which goes to a compulsory heir not because of the will of the testator, but by force of law. The legitim is something beyond the power of the testator to control. That's the reason why the legitim cannot be made subject to any condition. It cannot be made subject to any encumbrance. It cannot be made subject to any substitution. Let's assume that when A died, he did not have any properties other than those which came from X under the fiduciary substitution. Can be the other son of A claim part of those properties as is legitim from A? The answer is no. Because those properties were given to A under a fiduciary substitution, and therefore, those properties should go only to Mr. C. Supposing that A has many unpaid debts when he dies, can his creditors run after those properties? The answer is again no. Because at best, all that A has over those properties would be the rights of a usufructuary. All right. Let us assume that what Mr. X said in his will was something like this. I give all of my properties to A, but upon the death of A, whatever shall remain of those properties shall go to his son C. Is that a case of fiduciary substitution? The answer is, it is not. Why? There is an implied authority to dispose. Kung ano lang ang matira, yun ang pupunta kay Mr. C. There is no obligation to preserve and transmit all of the properties. That is what happened in that case of PCIB versus Escolin. Mrs. Hodges died with a will. In that will, she said, I give all of my properties to my husband, except for a certain property located in Lubbock, Texas, which she said she was giving to her relatives. Tapos sabi niya, whatever will remain of the properties I'm giving to my husband at the time of his death will pass to my relatives. That is not a fiduciary substitution because there is no obligation to preserve. As a matter of fact, may implied authority to dispose kung ano lang ang matira. Supposing that what happened is this. The testator gives 1/2 of this parcel of land to a niece. and the other one half to the brothers of the testator. Upon the death of my niece, whether before or after my own death, the one half given to her will pass to my brothers, or if they are dead, to their own heirs. Is there a fideikommissary substitution with respect to the one half given to the niece? The answer is there is none. The facts are similar to the case of Crisologo versus Singson. In that case, the Supreme Court said, there is no fideikommissary substitution. You can only have a fideikommissary substitution in either of two ways. Number one, by expressly calling it by that name. Tinawag ng testator, I am setting up a fideikommissary substitution, or I am designating so-and-so as fiduciary heir and B as fideikommissary substitute. Yan. You expressly call it by that name. The other way is by imposing upon a first heir the absolute obligation to preserve and transmit the properties to a second heir. Outside of these two situations, there is no fideikommissary substitution. What kind of substitution is this? According to the Supreme Court, that should be considered as a simple substitution. Let us assume that X institutes A and B as the heirs in a fideikommissary substitution. Sabi niya, I institute A as fiduciary heir and B as the fideikommissary substitute. Mr. B dies in 1995. X dies 1998. In other words, when X, the testator, died, B, the fideikommissary substitute, was already dead. A, the fiduciary, was still alive. Question, is there a fideikommissary substitution in this case? There is none. Remember, one basic requirement in Article 863 is both the first and the second heir must be living at the time of death of the testator. Ang tanong is, will A be able to inherit? The answer is yes. Why? Because of Article 868 of the Civil Code. The nullity of the fideikommissary substitution does not prejudice the right of the first heir to inherit. The fideikommissary clause will simply be disregarded. Supposing that it's the other way around. It was the first heir who died ahead of the testator. 1995, A died. So that when X died in 1998, only B was alive. Can B inherit? Strictly speaking, B cannot seem to inherit because there is no provision in favor of the second heir similar to Article 868. 868 refers to the first heir. But I submit the better view is that B should be allowed to inherit. We consider this as no longer a case of fideikommissary substitution because obviously there is no longer a valid fideikommissary substitution because of the death, the earlier death of the first heir. We can consider this as a case of simple substitution. Why? I go back to a basic premise and principle. In testamentary succession, the principal guiding star is always the intention of the testator. When the testator designated A and B as the heirs in a fideikommissary substitution, what was his intention? The intention is that ultimately, the properties will end with Mr. B. Because, in a fideikommissary substitution, the first heir only has temporary rights over the property. May katapusan, may hangganan ng kanyang karapatan doon. Ultimately, at the latest, at the time of his death, the property will pass to the second heir. That intention will best be served if we consider this as a case of simple substitution. Of course, in a simple substitution, if the instituted heir dies ahead of the testator, the substitute takes his place. All right. Always remember the restrictions, the limitations under Article 863. 1 degree, and number 2, both the first and the second heir must be living at the time of death of the testator. It is important to always remember these restrictions because they are incorporated by reference in other provisions. For example, in Article 869 of the Civil Code, if the testator gives the naked ownership of property to one person and he gives the usufruct of that same property to several persons, not simultaneously but successively. It should not go beyond the limits set in Article 863. Thus, if the testator, for example, says in his will, I give my farm in Bulacan to my friend F, but I give the usufruct of that property, that farm, to A for a period of 5 years, and after 5 years to B, the son of A, for another period of 5 years, and after 5 years to C, the son of B, for another period of 5 years. Here, naked ownership of that farm has been given to F, but the usufruct of the same property has been given to several persons, not simultaneously but successively. It cannot go beyond the limit set in Article 863. So, how do we apply the restrictions under Article 863 here? All of them must be living at the time of death of the testator. Number two, it cannot go beyond 1 degree from the heir originally instituted. Therefore, only A and B will get to enjoy that usufruct. C is already 2 degrees away from A. The same restrictions, same limitations are imposed in Article 867. For example, if the testator orders or gives his estate or a part thereof to an heir, but orders him to give to several persons successively a certain income or pension, it cannot go beyond the limits set in Article 863. So, kung binigay ang estate, the entire estate is given to F, but F is ordered to give A for 5 years, 10,000 monthly, and after 5 years to give B 10,000 monthly, and after 5 years to give C 10,000 monthly. Only A and B will be entitled to the 10,000 monthly income. Because in the case of C, he's already 2 degrees away from A, the first beneficiary. All right. The maximum period that the testator can order in division or prohibit alienation is what? 20 years. A testator is not allowed to perpetually prohibit the alienation of property. Hanggang 20 years lang. Supposing that he prohibits perpetually, I give my friend F my entire estate, but I prohibit him as well as any of his heirs from ever disposing any of the properties forever and ever. That is not a valid provision. But for the first 20 years, at least, it should be respected. That's binding, at least for the first 20. After 20 years, wala na yan. It can be disregarded. Having said that, you remember, however, that if the property is given under a fideikommissary substitution, the 20-year limitation does not apply. Ibig sabihin, if X says, I give my entire estate to A, but I order him to preserve and transmit the properties to his son B, tagal nang namatay ni X, more than 20 years ago. So, A is still holding the properties. Can A now dispose of these properties? No. Because even if more than 20 years had already elapsed, there is the overriding prohibition based on fideikommissary substitution. He is obligated to continue preserving intact all of the properties. He cannot alienate even beyond 20 years. Article 870 was the principal bone of contention in that case of Aranas versus Aranas. What happened in that case was this. There was a Catholic priest, Father Aranas. He died with a will. In that will, he disposed of his properties, basically in favor of his relatives. But there was a certain group of properties. Sabi niya, with respect to these properties will be under the administration of my nephew Vicente. As administrator of these properties, Vicente will be entitled to 1/2 of the fruits of the properties. In other words, Carmelo was in reality made a usufructuary. Under the will, Father Aranas further said, Vicente will continue as such administrator and consequently as usufructuary until he dies or until his refusal to go on as such administrator. Upon the death of Vicente, or upon his refusal to go on as administrator, the next administrator, and consequently the next usufructuary, will be one of the children of my brother Carmelo. So one of the next, after Vicente, pag namatay nito, o ayaw na, the next usufructuary will be one of the children of Carmelo, to be chosen by Carmelo. And if Carmelo is already dead, his children will select from among themselves who will take the place of Vicente. Father Aranas died. There was a case brought. Some of the relatives questioned the validity of this provision on the ground that it violates 870. Sabi nila, this amounts to a perpetual prohibition to alienate beyond 20 years. This is not valid. Nakaabot sa Supreme Court ang kaso. Ang sabi ng Supreme Court, there is no violation of Article 870. There is nothing which prevents Vicente from disposing of the fruits or even of transferring his rights as usufructuary. So, 870 is not violated. At any rate, sabi ng Supreme Court, Vicente is still alive. And he is still willing to serve as such administrator, usufructuary. So, that provision should be respected. When Vicente dies, sabi ng court, that is the time when the property can be properly disposed of subject to the limitations under Article 863 of the Civil Code on fideikommissary substitution. How does this relate to the topic, fideikommissary substitution? Remember, I told you earlier that the Supreme Court in Ramirez already said categorically the meaning of 1 degree is 1 degree of relationship by blood. If we consider Article 869, ang sabi dyan, if naked ownership of property is given to one person and the usufruct of that same property is given to several persons successively, it should not go beyond the limit set in Article 863. Ano ang limits? 1 degree at saka all must be living. This is obviously a case of successive usufructs. Diba? Ang first usufructuary will be Vicente. The next usufructuary will be one of the children of Carmelo. Between Vicente and any of the children of Carmelo, obviously, they are not first-degree relatives. So kung papayagan that the next usufructuary will be one of the children of Carmelo, iba na magiging meaning ng 1 degree. That is the reason why some have raised some doubts as to the continued validity of the ruling in Ramirez. But I have always maintained 1 degree still means relationship pursuant to Ramirez. Why? Hindi naman yan ang pinagtalunan dito eh. The issue here in Aranas was whether or not there was a violation of Article 870. Not whether 1 degree means degree of relationship. Moreover, I do not think my reading of Aranas tells me that the court did not actually categorically rule that the next usufructuary can actually be one of the children of Carmelo. Ang sinabi ng court is, well, after all, Vicente is still alive. Pag namatay na yan, or when he refuses, that's the time when the property may be properly disposed of subject to the limitations under Article 863. Put another way, in effect, as sinabi ng Supreme Court yan, saka natin pag-usapan yan, kung po pwede yan. Okay? So I submit, 1 degree should still be given the meaning of relationship, as held categorically in the case of Ramirez versus Ramirez. Let's now go to dispositions subject to a condition as well as dispositions subject to a term or period. A condition is a future and uncertain fact or event. A term or period is something which will necessarily come to pass, although we may not exactly know when. A condition may be potestative, casual, or mixed. When is it potestative? If the fulfillment of the condition depends upon the sole will of a party. It is casual if the fulfillment depends upon the will of a third person or upon chance. And it is mixed if fulfillment depends partly upon the will of a party and partly upon the will of a third person and or upon chance. The testator is allowed to impose conditions. Part of his right of disposition yan. He can impose conditions. An heir may be instituted subject to a condition. A legacy may be given subject to a condition. The condition, however, cannot be an impossible condition or an illegal or illicit condition. Supposing that the condition imposed is impossible, what's the effect? No effect. The heir will still inherit. If the testator, for example, says, I give my best friend F one half of my entire estate subject to the condition that within 6 months from the time of my death, he will demonstrate his ability to fly without using any mechanical device. F does not have to kill himself trying to fulfill that condition. He will still inherit. The rule is impossible and illicit conditions attached to testamentary dispositions are simply ignored, disregarded. Okay? Same rule in the case of donations. Di ba sabi natin, basta may impossible or illicit condition attached to the donation, you simply ignore. Because donations and testamentary dispositions are essentially predicated upon the generosity, the liberality of the donor or testator. You simply ignore them. There is a special rule when it comes to an absolute prohibition to contract marriage. Tandaan lang natin, an absolute prohibition to contract a first marriage cannot be validly imposed. Basta ang pinag-usapan natin dito, absolute. Yung talagang no ifs or buts, basta absolute. Hindi ka pwede mag-asawa. Yan, absolute yan. If it is a relative prohibition, pwede yan. A is instituted as heir subject to the condition that he will not marry until he reaches the age of 25. Pwede yan. Maria is given 1/4 of the estate subject to the condition that she will not marry until she reaches the age of 75. Hindi pwede yan. Okay? Kahit na mayroong termino, ikaw naman. Pag pinag-intay mo ang babae na hanggang 75 bago mag-asawa, para mo na rin nag-prohibit absolutely to contract marriage. So the circumstances must be considered. All right. My friend F is given one of the estate subject to the condition that he will not marry a Bicolana. O pwede yun. Relative yun. Pwede siya mag-asawa kahit sino. Wag lang daw Bicolana. Relative yun. With respect to a prohibition to contract a subsequent marriage, absolute prohibition to contract a subsequent marriage, the general rule is an absolute prohibition cannot also be validly imposed. Exception. Only certain individuals are allowed to impose validly the absolute prohibition to contract a second marriage. Sino-sino ito? The deceased spouse, the ascendants of the deceased spouse, the descendants of the deceased spouse. Sila lang ang pwede. Why are they allowed to impose this prohibition? By way of an exception from the general rule. Because, the law gives due consideration to the sensibilities, not only of the deceased spouse, but to the sensibilities of the ascendants, descendants of the deceased spouse, who, human nature being what it is, may not want another person to actually take the place of the deceased spouse in the life, the mind, and the heart of the surviving spouse. Yan ang reason. Love is supposed to transcend the limits of the grave. Sabi ng matatanda. All right. Let us assume that Mr. X had a first wife and a second wife. Hindi simultaneous, one after the other. Okay? Magulang ni W1 si A, magulang ni X si B, magulang W2 si C. First marriage, there are 2 children, D and E. Second marriage, F, G, and I. W1 is of course dead. And after the death of W1, H got married again. So, W2 has just died. Of course, there is no question that W2 is allowed to impose the prohibition on H because she is the deceased spouse. If C, the parent of W2, should make a will and in that will he should give some properties to H, can he also impose that condition? that H will not contract another marriage? Yes, because C is an ascendant of the deceased spouse. What about F, G, and I, the common children of H and W2? Can they also validly impose that condition on their father? The answer is yes, because undoubtedly, F, G, and I are descendants of the deceased spouse. What about B, the father of H? Can B impose that prohibition on his son? Pwede ba niyang bigyan ng properties, free portion ng kanya estate? O anak, nakadalawa ka na, huwag mong patatluhan pa. Otherwise, you will lose the free portion. The answer is no. Because B is not an ascendant of the deceased spouse. B is an ascendant of the surviving spouse. What about A? What about D? What about E? They cannot impose that prohibition anymore. Because ang deceased spouse na dito is si W2. Hindi na si W1. Sa matter of fact, nakapag-asawa na nga ito eh. Alright. So, only C, F, G, and I can validly impose the prohibition on H as well as W2, of course. Now, if you want to impose, let's say in the case of W2, if what she said in the will is, let's assume that they don't have any children, wala silang anak. So, the only compulsory heir of W2, aside from, let's assume that she is not, is already, would be H. Si H lang. If W2 said in her will, I give my entire estate to my beloved husband, but I do not want him to marry again. And H, just 6 months after the death of W2, contracted another marriage. Did he violate any condition? The answer is no. Tanda natin, a mere expression of a wish or a desire does not amount to the imposition of a condition. She was merely expressing a wish, a desire. She was not actually imposing a condition. Halimbawa, ang nangyari ganito. W2 said, I give my entire estate to my husband, subject to the condition that if he marries again, he will lose everything. Is there a valid imposition of a condition? Yes. If H marries again, will he lose everything as stated in the will? No. Why not? Remember, he was given the entire estate. He gets part of that as legitimate. The legitimate cannot be subject to any condition. H, in that case, will only lose the free portion. So, kalahati lang ang mawawala sa kanya. He retains the legitimate. Because the legitimate, I repeat, cannot be subject to any condition, cannot be subject to any encumbrance, cannot be subject to any substitution. Because the legitimate goes to the compulsory heir, not because of the will, but because of the law. Next point. Remember what a disposition captatoria is. Ano yung disposition captatoria? If the testator gives property to an heir, subject to the condition that that heir, in his own will make a disposition either in favor of the testator or a third person, that is null and void. Because succession cannot be the object of a contract. You are not allowed to control the will of another person by imposing that kind of a condition. If the testator has imposed a condition which is potestative in character, when should the condition be fulfilled? Since fulfillment depends upon the sole will of the heir, then the law says, if the condition is potestative, it may be fulfilled as soon as the heir learns of the death of the testator. If the condition, on the other hand, is casual or mixed, like passing the bar examinations, anong klaseng condition yan? It's mixed. Mixed yan. Hindi natin pwede sabihin na potestative yan. Sobra naman ang bilib mo sa sarili mo kung potestative. I also do not believe that it is casual, na everything depends upon chance or the will of the examiner or the chairman. Hindi naman. Depends partly upon your will, the amount of effort you exert, and upon a certain extent, chance or the will of third persons. If the condition imposed is casual or mixed, when should it be fulfilled? It may be fulfilled at any time, either before or after the death of the testator. If at the time of the execution of the will, the testator did not know that the casual or mixed condition has already been fulfilled, What is the rule? The rule is, kung hindi niya alam, he did not know that it has already been fulfilled, it is already deemed complied with. If, on the other hand, at the time that the testator made his will, he knew that the casual or mixed condition he was imposing has already been fulfilled, and he imposed it again, that only means that he wants the condition to be fulfilled again. Unless, of course, the condition is of such nature and character that once fulfilled, it cannot be fulfilled again. Testator says in his will, I gave one half of my estate to my friend F, subject to the condition that he shall earn a masteral degree. When the testator made his will, he knew that his friend F already has a masteral degree. Should F earn another master's degree? Yes. Because the testator was aware that he already had a master's degree, so he should earn another one, because the testator imposed it. But supposing that the testator says, I give my friend F one half of my estate as heir, subject to the condition that not later than 5 years after my death, he should take and pass the bar examinations. The testator knew that his friend F was already a lawyer, but he still imposed that condition. Gusto niyang pakurin ulit ng bar. Ibang usapan na yan. Hindi na pwede. Because the condition is not possible of fulfillment again. The Supreme Court will not allow you to take the bar again if you have already passed it. Although, of course, if you don't make it, hanggang 5 attempts. If a disposition is made by the testator subject not to a condition, but to a suspensive term or period, I gave my friend A one half of my properties as heir, but he will get this only after 5 years from the time of my death. That is an institution subject to a suspensive term or period. What is suspended is merely the demandability, not the effectivity of the institution. Consequently, even if the instituted heir dies before the arrival of the suspensive term or period, he would already have acquired rights which he can transmit to his own heirs kung suspensive term or period. Now, what will be done with the property in the meantime if the institution is subject to a suspensive term or period? Ang sabi ng testator, I give one half of my estate to my friend F, but he will get it only after 5 years from the time of my death. So, ito yung time of death, ito yung 5th year. During this period, what will be done with the properties given to the heir while you're waiting for the arrival of the suspensive term? There is a conflict between Article 880 and 885. Ang sabi ng Article 880, if the institution is subject to a suspensive term or a suspensive condition, the property will in the meantime be placed under administration. Ang sabi naman ng Article 885, if the institution is subject to a suspensive term, the property will in the meantime be given to the legal heirs of the testator. Alin ba talaga? It should be Article 885. As long as the institution is subject to a term or period, whether suspensive or resolutory, the applicable provision is Article 885. The references to a term or period in Article 880 is erroneous. So, applying Article 885, since the period is suspensive, during this 5-year period, the legal heirs will get to enjoy the property. They'll have the same rights as usufructuaries. Upon the arrival of the 5th year, the properties will be given to the instituted heir. But under Article 885, before the legal heirs can take possession of the properties, kailangan may security. They're required to post a security to guarantee that upon the arrival of the term or period, the properties will be transmitted intact to the instituted heir. If the institution of the heir, upon the other hand, is subject to a resolutory term or period, then upon the death, halimbawa sabi, I give my properties to my friend F, but he will enjoy it only for a period of 5 years. So upon the death, the instituted heir will get the properties. Upon the arrival of the resolutory term or period, his rights are extinguished, terminated. The properties would now go to the legal or intestate heirs of the testator. Article 885. If you are instituted under a suspensive condition, upon the other hand, apply Article 880. Prior to the fulfillment of the condition, while the whole world is waiting with bated breath whether or not the condition will be fulfilled, what will be done with the properties? Under administration yan. The heir is not allowed to secure the properties even if he's willing and able to post a security. Property must be placed under administration. Remember what an institution sub modo is. Modal institution. You have the provisions of Article 882. When is an institution considered modal? If the testator specifies the object of the institution, the charges to be satisfied by the heir, or the application of the property. Or memory guide is OCA, OCA. Object, charges, application. The moment the testator specifies the object, charges, or application, that in all probability will be a modal institution. What is the legal consequence? How does this work? If the institution is modal, the instituted heir is immediately entitled to the properties given to him under the will, even before he has satisfied the charges or the object specified by the testator. Halimbawa, the testator says, I gave my best friend F the entire free portion of my estate, but I order him to use 20% of the income from these properties for the purpose of putting up and maintaining a charity clinic for the indigents in our locality. That is a modal institution. The testator has specified the object of the institution as well as the charges imposed on the heir. So, upon the death of the testator, the institution being modal, F will be immediately entitled to the properties given to him, subject, of course, to the usual settlement proceedings, even before he has put up the clinic. But he is required to post a security to answer for the return of the property as well as all the fruits and interests due thereon, in case he does not comply with the wishes of the testator. Remember the difference between a mode and a condition. A mode obligates but does not suspend. A condition suspends but does not obligate. So I repeat, a mode obligates. Obligado ka to comply with the orders of the testator, but it does not suspend. You are immediately entitled to the properties given by will, even before you have actually complied with the orders of the testator, subject to the posting of a security. A condition, on the other hand, suspends but does not obligate. A good illustration of a model institution would be the case of Rabadilla versus Court of Appeals. In that case, the testatrix executed a codicil to her will. In that codicil, she gave a certain parcel of land to Dr. Rabadilla. Ang sabi ng testatrix, I'm giving this property to Dr. Rabadilla, but I order him to give annually to some of my relatives who were named there, I think 100 pickles of sugar. So, that is a model institution, according to the Supreme Court. Okay? Legitimes. Ito ang isa sa pinaka-importante na topic sa succession. We cannot hope to correctly solve many problems in succession unless we know what the legitimes of the compulsory heirs are. So, medyo pumasada tayo sa law on legitimes, especially the table of legitimes. Tandaan lang natin, rule of thumb, legitimates are always entitled to one half. Any class surviving alone, walang kahati, isang klase lang ng survivor, one half yan. Okay, unlegitimate. Surviving spouse, surviving alone, one half, unlegitimate. Kung walang ibang compulsory heirs, one half. Exception, if the marriage was solemnized in articulo mortis and the testator died within 3 months, the law looks with a little bit of suspicion at that marriage and reduces the legitime of the surviving spouse in that case to only 1/3. Bakit may suspicion? Because as I said, the marriage might have been impelled by economic considerations. Exception to the exception. Even if the marriage was contracted in articulo mortis, even if the testator died within 3 months following the celebration of the marriage, if the parties had been living together as husband and wife for at least 5 years, the law raises back the legitim to 1/2. Okay? Baka naman talagang totoong may pag-ibig because they have been living as husband and wife for at least 5 years. So, general rule, 1/2. Exception, 1/3. Exception to the exception, 1/2. Okay? It is necessary, however, that for the exception to apply, kailangan marriage in articulo mortis. Because if H and W, both healthy, were married at 7 o'clock in the morning, and that same evening at 7 o'clock, during the honeymoon, H suffers a massive heart attack, assuming that W is the only compulsory heir, the legitim is 1/2. Does not matter that the marriage lasted only for several hours, because it was not a marriage in articulo mortis. The dying party must be the one who should actually die. H and W were married in articulo mortis, January 1. The marriage was in articulo mortis because W was dying. Talagang, even the doctor said, she can go any minute. So, it was solemnized in articulo mortis, January 1. And H nursed W back to health. Okay? By February 14, W was well enough, in perfect health. So, they finally had their long-delayed honeymoon. That evening, February 14, H suffers a massive heart attack. Patay. What's the legitim of W? 1/2. Why? It was W who was dying when the marriage was solemnized. But it was H who died within 3 months. Ang kailangan matuluyan, yung himamatayin. Okay? Otherwise, you don't apply the exception. Alright. Legitims. The presence of legitimate children and descendants excludes the legitimate parents and other ascendants. The presence of an adopted child is sufficient to exclude the legitimate parents and other ascendants. Consider an adopted child just like a legitimate child. If the survivors are legitimate parents, illegitimate children, surviving spouse, legitims, 1/2 to the legitimate parents, 1/4 to the illegitimate children, and only 1/8 to the surviving spouse. All right. Survivors are illegitimate children and surviving spouse. Legitims, 1/3, 1/3. Survivors are illegitimate parents and surviving spouse, 1/4, 1/4. Survivors are illegitimate grandparents and surviving spouse. The illegitimate grandparents are not compulsory heirs. Legitim of the surviving spouse is 1/2. Remember that in succession, whether under the law on legitims or in intestate succession, in the direct ascending line, in case the decedent is an illegitimate person, succession stops at the illegitimate parents. Only F can inherit from X. GF is not entitled to any legitim. Hanggang illegitimate parents lang ang succession if the decedent is an illegitimate person. Sabi nga natin, this is a rather unique situation. Why? Usually in succession, It's a two-way street. If I can inherit from you, you can also inherit from me. Two-way. Pero pagdating dito sa mga illegitimates, one way. Okay. Let us assume that GF, the illegitimate grandfather of X, died. Can X inherit from GF? Yes. Walang problema yan. An illegitimate descendant can inherit from an illegitimate descendant. So, pwede mag-inherit. But supposing it is X who dies, survived by GF. Can GF inherit? He cannot. He cannot. Kung wala na si F, wala yan. Kabalikat sa ating kaunlaran, the state, ang makikinabang dyan. Okay? I repeat, sa illegitimate persons, succession in the direct ascending line stops at the illegitimate parents. Under the family code, illegitimate children are entitled to a legitimate, which is one half of that given to the legitimates. Okay. It may happen, however, that they may end up with less than one half. Posibleng mangyari yan. Kung makulay ang buhay ng testator, decedent. X, survived by W, surviving spouse, and A and B, legitimate children, and C, D, E, F, G, H, illegitimates. Estate is 120,000. How much would be the legitimes of the survivors? Pagdating sa hatian, legitimes, etc., always give preference to the legitimate children. Yan ang unahin mo. So, legitime of the legitimate children, one half of the entire estate. One half of 120 is 60,000. A and B, therefore, are entitled to 30,000 each by way of legitime. After satisfying the legitimes of the legitimate children, you satisfy the legitime of the surviving spouse. Legitime of surviving spouse, the same share as one legitimate child. So, W, 30,000 din. Under the family code, C, D, E, F, G, H are supposed to get, by way of legitime, one half of the share of a legitimate child. So, theoretically, C, D, E, F, G, and H theoretically should get how much? 15,000 pesos each. But you only have 30,000 pesos left. What's the net consequence? C, D, E, F, G, H will just have to share the 30,000. Since there are 6 of them, you only have 30,000 left. Each one will get 5,000 pesos. Okay? Ganyan ang buhay. Alright. One legitimate child concurring with the surviving spouse. Legitimate. Oh, basta may legitimate, one half. One half to the legitimate child. Surviving spouse, 1/4. 1/4. So, free disposal will be 1/4 also. Okay? Tandaan natin yung mga rules on legitime. Only survivors are illegitimate children. O anong legitime? One half. Any class surviving alone gets one half. Survivors are 2 legitimate children and surviving spouse. Legitime. O, may legitimate. So, bigyan mo ng kalahati yung legitimate children. Okay? Which they will divide equally. Then, after determining the share of each legitimate child out of the one half, you give the surviving spouse the same share as one legitimate child. Okay? Madali lang naman. It's not really that complicated. Yeah. The law on legitimes. Recall the provisions of Article 905. There can be no waiver of future legitime. There can be no valid compromise with respect to future legitime. any such waiver or compromise is considered void. But the compulsory heir concerned is obliged to bring to collation whatever he may have received by virtue of the waiver or compromise. This brings us to the concept of collation. Ano ba itong sinasabing collation? When a person dies, whether or not he has a will or he dies intestate, there is always a process of collation. There are actually three meanings of collation as that term is used in the Civil Code. The first meaning of collation is, collation means addition. Addition. Ano ibig sabihin? The value of all gratuitous dispositions, the value of all properties, which were gratuitously disposed of by the decedent during his lifetime, their values are added to the estate. Value. So, collation in the sense of addition means a mathematical process of adding the values of all properties previously disposed of gratuitously by the decedent. Their values are added to the estate. The second meaning of collation is charging or imputation. All gratuitous dispositions made in favor of compulsory heirs are generally charged against the legitim, considered as an advance of the legitim. Gratuitous dispositions made in favor of third persons who are not compulsory heirs are, on the other hand, charged against the free portion. Okay. There is a third meaning of collation in the sense of an actual restoration of the property. But commentators, civilists are practically unanimous in saying that that is not really collation, yung actual restoration of the property. That actually happens only when a donation is held to be totally inofficious. That's when the property itself will have to be returned. Okay, so we will concern ourselves with the two meanings of collation. Collation in the sense of addition and collation in the sense of charging or imputation. As I said just a while ago, the first meaning of collation is addition. All gratuitous dispositions made by the decedent during his lifetime, the value of the properties he disposed of gratuitously will be added to his estate. What's the purpose? To determine the total hereditary estate, which will in turn be the basis for determining the legitims of the compulsory heirs. So all, lahat ng mga pinamigay, properties, their values will be collated. The Civil Code gives us specific rules on collation. I refer to Articles 1061 up to Article 1077. Generally, all, or practically all, gratuitous dispositions are subject to collation. There is only one situation when certain gratuitous dispositions made by a decedent during his lifetime are completely not subject to any collation. Their value will not be added to the estate. There is just one situation. I refer to the provisions of Article 1067. Yan lang. In the other provisions of the Civil Code in Articles 1061 up to 1077, pag sinabi ng law dyan na shall not be subject to collation, ang ibig lang sabihin yan, it will not be charged against the legitim. But it will still be collated in the sense of addition. Yun lang. But in Article 1067, pag sabi ng law dan, not subject to collation, the law means exactly that. Absolutely not subject to collation. So, ano itong items na ito under 1067? Support, education, medical attendance, even in the case of extraordinary illness, apprenticeship, customary gifts, ordinary equipment. Ibig sabihin, na-confine ka sa ospital, na ICU ka ng 1 buwan. Sang katutak ang gastos niyan. Let's assume that your father spent 3 million for your hospitalization. The 3 million will not be considered when your father dies and when you try to distribute the estate. 3 million will not be added to the value of the estate. It's completely ignored. Support. Lahat ng nakain mo, kahit na medyo malakas kang kumain, simula nung maliit ka, support yan. Okay? Not covered by collation. Customary gifts, pa-birthday, mga papasko, okay? Year after year, wala yan. Completely not subject to collation. Education is mentioned in Article 1067. Pagdating sa education, we distinguish between tertiary, college, and education before that. So, up to high school, hanggang high school, covered by 1067. Completely not subject to collation. Yung nagasta ng magulang mo sa pagpaparal sa iyo hanggang high school, that's not taken into account. Pero yung nagasta sa iyo, pagdating mo ng college, that's covered not by 1067 but 1068. Expenses incurred by parents in giving their children professional, vocational, or other career. But you don't have to worry even then. Even if it is covered by Article 1068, in other words, the value, the amount spent by your parents in sending you to school will be added to the estate when it comes to charging or imputation. That is not considered as an advance on your legitim. That is chargeable against the free portion. Kasama dyan, yung incidental expenses, not just tuition, yung nagasta niya sa pagbili ng mga libro. Okay? Medyo mahal ang law books, for example, or medical books, kakapal niyan, mahal yan. They are not charged against the legitim. Generally, they are charged against the free portion. Unless otherwise provided by the parent, in which case, however, whatever the parent would have spent if the child had simply stayed at home will be taken into account. Or unless there is a clear impairment of the legitim of other compulsory heirs. Okay. Ano pang special rules sa collation? Panahon ngayon ng eleksyon. Talagang sangkatutak ang gastos ng mga kandidato. May mga magulang na mahilig magpakandidato ng kanilang mga anak, kahit naman walang kapanapanalo. Alright. Gagastahan yan. Milyon ang bibigay dyan. Sige, tumakbo ka. Okay? Siga tayo dito sa bayan natin. Election expenses. Charged against the legitim. Same thing with fines, indemnities paid by parents on behalf of their children. That is charged against the legitim of the child concerned. Okay? Donations given to daughters-in-law or sons-in-law, charged against the free portion yan. Because an in-law, regardless of the fact that you are the favorite in-law or outlaw, you are not considered an heir. You are not entitled to any legitim. Siyempre naman. Okay? Dagdag ka lang dun. Donations given to grandchildren. Remember the special rule for grandchildren. Okay? Let's assume that X has 2 children, A and B has a son, C. X donated a parcel of land to his son, B. X also donated to his grandson, C, let's say, a car. All right. X dies. The value of the land will have to be collated, of course, together with the value of the car. Their values will be added to the estate. When it comes time to charge or impute the donations, the value of the land will be imputed, charged against the legitim of B. The value of the car will of course be charged against the free portion because C is not going to inherit. Buhay pa yung tatay niya. Okay? Let us assume, however, that B sold the land to Mr. Zay. And then, after selling that land to Zay, tuwan-tuwa siya. Okay? Umiinit yung pakiramdam niya, umiinit yung pera sa bulsa niya. He spent the entire proceeds of the sale in one whole night at the casino. Okay? Ubos. Sabihin natin 10 milyon yun. Ubos. And then he dies. So, C will now be inheriting from X. Under this situation, even if C did not benefit from that land, hindi siya nakinabang doon. Hindi niya namana yun, he did not inherit any part of the proceeds. C is obliged to bring to collation not only the value of the car, but even the value of the land. That's the rule for grandchildren. Okay? Kahit na hindi siya nakinabang dun sa value ng land. He's obliged to bring that to collation. Okay. You have, in this regard, the provisions of Article 1064. Remember the special rule for wedding gifts, consisting of jewelry, clothing, and outfit, under Article 1070 of the Civil Code. As long as they don't, or to the extent that they don't exceed 10%, hanggang 10% of the free portion, these wedding gifts consisting of jewelry, clothing, and outfit will be charged against the free portion. Any excess over the 10% limitation will be charged against the legitim of the child concerned. By the way, you remember, if the testator has donated a property to a compulsory heir, and in the deed of donation, ang sabi niya doon, this donation is irrevocable. Ibinibigay ko sa isang pamamaraan na hindi na muling mababawi. Walang bawian. That donation is still subject to collation. That was made clear by the Supreme Court in De Roma versus Court of Appeals. Even if the donation is irrevocable, sabi, it is still subject to collation. Let's assume that X has 4 legitimate children. A, B, C, D. D is married to W, and B has a son, A. During the lifetime of X, he made the following dispositions, or he incurred the following expenses. He spent 300,000 for the hospitalization of A. He also spent 30,000 when his son B ran for public office. Yun ang contribution niya. 30,000. He gave his grandson a ring worth 10,000 pesos. He gave his favorite daughter-in-law W a bracelet worth 20,000. When D got married, he was so happy about it, he gave D a wedding gift consisting of jewelry worth 40,000. And finally, he spent 10,000 for the college education of C. X died with a will, and in that will he said, I institute my 4 children as my heirs. His gross estate is 1 million. Gross estate includes everything. Lahat ng mga properties, assets, etc. Nandiyan yan, gross. He had debts amounting to 500,000. Okay. So, ano ang dapat gawin? If you're asked to distribute an estate, siyempre, usually ang gross, that's given. Okay. First step, deduct the debts and other charges from the gross estate. Okay? All right. So, you are left with a net estate of 500,000 after deducting these debts. What are you supposed to do next? Collation. Collation in the sense of addition. You add the value of all gratuitous dispositions. These are the gratuitous dispositions made by X. But applying Article 1067, we completely ignore item number 1, yung 300,000 na nagasta niya. That's not subject to collation, not even in the sense of addition. Therefore, we only collate these 5 items. Total amount, 110,000. Supposing that the bracelet given to W, although it was worth only 20,000 before, is now worth 200,000. What is the amount which should be collated? Remember, pagdating sa collation, it is always the value of the property at the time of the donation. Okay? Any subsequent increase or diminution will be for the account of the donee. So, nakapako yan. Kung anong value at the time of disposition, yun na yun. Okay. So, we collate 110,000, collate in the sense of addition. We add that to the net of 500,000, and we arrive at a total hereditary estate of 610,000. Okay. Next step. After you have determined the total hereditary estate, you are now ready to determine what? The legitimes of the compulsory heirs. Based on the total hereditary estate which was arrived at only after collation. So, legitime of the legitimate children, ABCD, 1/2 of 610,000. Kalahati nun. That's the legitime of the legitimate children. Okay? Therefore, by way of legitime, A, B, C, and D, by way of legitime, will each be entitled to 76,250. Total of 305,000, which is exactly 1/2 of 610. Okay? Pinagati-atin la, yan ang legitimes. Therefore, since total legitimes is 305,000, yung kalahati nun, the other half, yun ang ating free portion. Very good. So, the free portion is the other 305. Okay. After you have determined total legitimes, free portion, next step, collation again. This time, collation in the sense of imputation or charging. Okay? So, isa-isahin natin ang mga items which we had earlier collated. Election expense incurred by the parent for son B. Against what part do we charge or impute that? Legitimate yan. Deduct 30,000. In other words, in terms of the actual distribution of properties, B should get less, 30,000 less in actual property. Kasi matagal na niyang tanggap yun. Nauna na. Matagal nang naibigay sa kanya yun. The 30,000 election expense is considered an advance or is legitimate. 10,000 worth ring given to the grandson. B is still alive. Therefore, the ring, the value of the ring given to E will be charged against the free portion. Less 10,000. Bracelet given to W. Basta in-law, kanyan, considered as donation to a stranger. Less another 20,000. Wedding gift consisting of jewelry given to D. A special rule. under Article 1070. Anong special rule? Up to 1/10 of the free portion, that will be charged against the free portion. The excess will be charged against the legitim of the heir concerned. Our free portion is 305,000. So how much is 10% of that? 30,500. So up to 30,500, the wedding gift given today will be charged against the free portion. Eh, ang kaso 40,000 yun. May sobra. So, how much is the excess? 9,500. The 9,500 excess over the 10% limitation will be charged against the legitim of D, less 9,500. Okay? All right. College education of C, 1068. That is charged against the free portion generally, unless otherwise provided by the parent or unless there is impairment of legitims. So, less 10,000. After all of these deductions, we are left with 234,500 pesos. What do we do with this? Divide by 4. Kasi sila ang instituted heirs. So, divided by 4, that will give us 58,625, which will be added here. Okay? That's basically how it works. Okay. Still on collation. Let's assume that X has 2 legitimate children, A and B. 1 illegitimate child, C, surviving spouse, W. All right. Let us further assume that sometime in 1975, A, the eldest, much like the prodigal son in the biblical parable, demanded from his father, you give me my inheritance now para mapagkanabangan ko. Okay? The father relented and he agreed. He gave a parcel of land, which at that time was worth 20,000 pesos. And A, in turn, together with X, executed a compromise agreement. Under that compromise agreement, A waived his right to any future inheritance from his father. All right. When X died, he left a will. And in that will, he instituted as his heirs. Sabi niya, I institute as my universal heirs my children B and C. W is not mentioned. A is not mentioned. Before we proceed, is there preterition? Wala. No preterition. Why? In the case of A, nakatanggap na yan. Tagal na. The omission is not total and complete. In the case of W, asawa lang yan. So, pwedeng ganyan. Walang preterition yan. Walang problema. Alright. Not a compulsory heir in the direct line. Alright. When X died, he had a gross estate of 200,000. He had debts amounting to 100,000. Okay. So, ilan ang net estate natin? 100. Next step, collation. We collate. We collate the value of the land which was donated in 1975. If that land is already worth 2 million, we still collate only 20,000. Nakapako na yun doon. So, collate 20,000. The total hereditary estate is therefore 120. Having determined the total hereditary estate, which is 120,000, next step, determine the legitims. Okay. Kasama pa rin yan si A sa pagdetermine ng legitim. Because that waiver, that compromise is not valid. So, A, B, C, and W. 1/2 of 120,000 is the legitim of the legitimate children. So, 1/2 of 120 is 60. A and B, being legitimate, are entitled to 30,000 each by way of legitim. The surviving spouse is entitled to the same share as one legitimate child. So, 30,000 also. C, being illegitimate, is entitled by way of legitim to 1/2 of the share of a legitimate child, 15,000. The remaining 15,000 will go to whom? May sobra pang 15. That will go to B and C because they are the instituted heirs. So, B gets an additional 7,500. C gets an additional 7,500. We also collate in the sense of charging or imputation, of course, the value of 20,000, which was earlier donated to A. Therefore, while A is entitled to a legitim of 30, ang ibibigay sa kanya ngayon, 10,000 na lang. Kasi matagal na niya natanggap yung 20,000. Ha? Yan ang ibig sabihin ng charging or imputation. Alright. If the free portion, okay, in distributing the estate, the principal provision to take into account is, of course, Article 911. Yan ang principal rule to be applied when it comes to distribution of estate, collation. Of course, whatever happens, the legitim will always have to be protected. Unahin mo, ibigay ang legitims sa compulsory heirs. Now, if in the will of the decedent, of the testator, there are legacies and devises. May mga legacies and devises yung pinamimigay doon, especially in favor of third persons. And during his lifetime, he also made various donations inter vivos. And the free portion is not sufficient to completely cover the value of all donations inter vivos as well as all legacies and devises in the will. What is the rule to be applied? Preference is given to the donations inter vivos. Before you even attempt to satisfy the legacies and devices, before you even attempt to charge the legacies and devices against the free portion, unahin mo munang i-charge against the free portion yung donations inter vivos. Why are donations inter vivos preferred as against legacies and devices? The answer is simple. Number one, donations inter vivos are basically irrevocable. They're basically irrevocable. You cannot allow, therefore, the testator to, in effect, revoke his earlier donations by simply giving out so many legacies and devices. And of course, number two, they come well ahead of the legacies and devices. Priority in time is priority in right. So, only after you have charged against the free portion, the donations inter vivos, should you attempt to satisfy the legacies and devices in the will. As among the legacies and devices, what is the order of preference in trying to satisfy them? Simple lang. You first satisfy those which are declared preferential by the testator. So, number one, priority, preferential legacies and devices. Next, all others pro rata. Yun lang, ang order of preference among the legacies and devices. Okay, example. How do we apply these rules enunciated in Article 911? Especially the preference given to donations inter vivos as against legacies and devises. Let us assume that Mr. X has 3 legitimate children, A, B, and C. Surviving spouse, W. During his lifetime, he made the following donations inter vivos. 1975, there was a donation inter vivos in favor of his son A, parcel of land, worth 20,000. And in 1988, there was another donation inter vivos in favor of his friend F of another parcel of land worth 70,000. X made a will. In that will, he instituted as his heirs A, B, C, and W. And in the same will, he made the following legacies and devises. Samahan natin ang legacies and devises para makita natin yung how the preference given to donations works. So, legacies and devices. First, there was a house and lot worth 70,000 given to his friend G. Next, there was a legacy of a car worth 30,000 in favor of his friend H. Finally, there was a cash legacy of 60,000 pesos in favor of his other friend I. Okay, so house and lot, device, legacy, car 30,000, cash legacy 60,000. So total legacies and devices 160,000. Okay. When X died, he had a gross estate of 400,000. He had debts amounting to 40,000. Net estate 360,000. What do we do? Again, first step, after determining net estate, ano? Collation. Siyempre, collation. What are the items subject to collation? There are two donations, 20,000 and 70,000. By the way, don't make the mistake of collating yung value ng legacies and devices. Sa will yan eh. Okay? Hindi pa naibigay yan. Alright. So we collate these two donations. Plus 20, plus 70. Therefore, we arrive at a total hereditary estate of 450,000. Okay? We are now ready to determine legitimes of the compulsory heirs. A, B, C, and W. What would be their legitimes? 1/2 of 450,000 would be 225,000 divided by 3. That will give us 75,000 by way of legitime for each of the legitimate children. So A is entitled to 75,000 legitime, B 75,000, C 75,000, and of course W is entitled to the same share as one legitimate child, 75,000 also. Total legitimes is therefore 300,000. Our total estate is 450. So, if we deduct the total legitimes of 300 from 450 less 300, that will give us a free portion of 150,000 pesos. Okay? So, this is our free portion. Having done that, we now go through the process of collation. Okay? Collation. Donation given to A. Against what part of the estate do we charge that? Legitime. That's a donation given to a compulsory heir. So, we deduct 20,000 from A. In other words, while his legitime is still 75,000, he will now get only 55,000. Kasi nauna na yung 20,000 nun. Next item, 70,000 worth of land donated to F. Obviously, that is chargeable against the free portion. Less 70. 80,000 lang ang natitira. Please take note, Before we even attempt to satisfy the legacies and devices, inuuna nating i-charge against the free portion yung donation inter vivos. That is what I meant earlier when I said donations inter vivos are preferred as against the legacies and devises. Okay, so 18 na lang titira. Itong 18 na ito, itong bibigay dito sa legacies and devises. Obviously, they cannot all be fully satisfied. And since the testator did not express any of these to be preferred, they will all be reduced proportionately. Kung sinabi ng testator, the legacy in favor of I is a preferred legacy, you give 60,000 to I. Tapos yung remaining 20,000, yun ang paghahatian ni G at saka ni H. But since he did not express any preference, all of them will be reduced proportionately. As a matter of fact, it's very clear that the reduction is exactly 1/2. Kasi 160 ang total, 80 lang available. So, the 70,000 legacy will be reduced to 35, device rather, 35. The legacy of a car will be reduced to 15, and the cash legacy of 60,000 will be reduced to 30,000. Total, 80,000. That's how the estate should be distributed. Okay. And this in turn brings me to the next point. Article 912. Article 912 says, if the device consists of real property which cannot be conveniently divided, it shall go to the devisee if the reduction does not absorb 1/2 of its value. And in a contrary case, it will go to the compulsory heirs with the corresponding obligation to reimburse each other. If the reduction of the device, I think we can agree that a house and lot cannot be conveniently divided. Okay, so it's real property which cannot be conveniently divided. The reduction is exactly 1/2. Ang tanong is, who will get that house and lot? Will it go to the heirs of X with the obligation to simply pay 35,000 to the devisee, or will the house and lot go to the devisee at yung devisee nilang magbabayad ng 35,000 sa heirs? If we apply Article 912 literally, it would seem that the property should go to the heirs. Okay? Kasi ang sabi, it shall go to the devisee if the reduction does not absorb 1/2 of its value. So kung exactly 1/2, literally, dapat mapunta sa devisee. But I think the better view expressed by some civilists like Justice Paras, Tolentino, for example, the better view is that if the reduction is exactly 1/2, it should go to the devisee. Why? Again, we go by the intention of the testator. Obviously, the testator intended the house and lot to go to the devisee. So as much as possible, we should respect that intention. If the reduction is exactly 1/2, give it to the devisee. The devisee will simply pay the heirs the amount of reduction. Next point. What about the car? The car is not real property. It's personal property. But then again, a car is also property which cannot be conveniently divided. Hindi mo pwedeng hatiin yung kotse. Okay? What rule are we going to apply? Although Article 912 mentions only devices of real property, I do not see any reason why the same rule should not also be applied to a legacy of personal property which cannot also be conveniently divided. Otherwise, what rule are you going to apply? Okay, so what has been said should apply with equal force to a legacy, just like of a car, or personal property which cannot also be conveniently divided. Okay? All right. On disinheritance, of course, you can only deprive a compulsory heir of his legitim through a valid disinheritance. And you can only have a valid disinheritance through a valid will. So, if a father gets very, very mad at his son because the son had done something terribly wrong, And he says, you'll not inherit anything from me. Okay? I'm disinheriting you. Wala yon. Okay? A disinheritance can only be made through a valid will. The cause for the disinheritance must of course be stated in the will, and it must be a cause is recognized by law. If, for example, a father says in his will, I disinherit my youngest son because he looks more like our neighbor than me, that's not a valid disinheritance. The disinheritance must be based on an existing cause. Kailangan nandiyan na, meron ng cause already committed. It cannot be made conditional upon the happening of a certain event. If a father, for example, says, if my daughter should ever live a dishonorable and disgraceful life, she will be disinherited. Wala pa namang ginawang anomalya yung kanyang anak. But 3 months later, the daughter eloped with the family driver who is a married man and started cohabiting with him. Is there a valid disinheritance? There is none. Because when the disinheritance was made, there was no existing cause. Of course, the cause must be a true cause. While a disinheritance cannot be made conditionally, the revocation of the disinheritance may be made conditional. So, the daughter, the father's pet, has eloped with a married man and is cohabiting with that married man. So the father says, I hereby disinherit my daughter because she is leading a dishonorable and disgraceful life. She is cohabiting with a married man. If, however, she should mend her ways, leave that man and return to her home and serve me well, then this disinheritance shall not be valid. Shall be revoked. Is there a valid disinheritance? Yes. Because there, what is conditional is not the disinheritance. There is a valid existing cause. It is the revocation, which is made conditional. Pwede yon. A disinheritance cannot be partial. Why? Because disinheritance is based on the offense committed against the testator. The testator is either offended or he is not. Hindi pwede sabihin na he is only half offended. A father cannot disinherit his son by saying, I disinherit my son because he maltreated me and I deprive him with respect to 1/2 of his legitimate. That is not a valid disinheritance. The son will still be able to inherit. Okay? Hindi pwedeng kalakalahati. Either you are offended or you are not. What are the grounds for a valid disinheritance? You find these grounds enumerated in Articles 919 for disinheritance of children or descendants, 920, disinheritance of parents or ascendants, and 921 for disinheritance of a spouse. By the way, who has the burden of proof? If the disinherited heir questions the validity of the disinheritance, questions the basis, the burden of proof is on the other heirs who want to uphold the disinheritance. Okay. Let's go over these grounds, at least some of them. Many of them are common grounds, by the way. Right. One of the grounds for disinheriting a child or descendant is if a child or descendant has been found guilty of an attempt against the life of the testator, his or a spouse, ascendants, or descendants. Found guilty. Okay? That implies that there is a conviction by final judgment. Mere attempt is sufficient. If you try to kill your brother, your father can disinherit you. Because there is, assuming you are found guilty, because there is you are found guilty of an attempt against the life of a descendant of the testator. Supposing you were extended presidential pardon by the President of the Philippines, absolute pardon, can you still be disinherited? Yes, you can still be disinherited. The absolute pardon does not erase the offense which you have already committed against the testator. You attempted to kill your father. You were not prosecuted because your family wanted to avoid a scandal. Can you be validly disinherited? Yes. Not because of conviction, because there is no conviction, but this time for maltreatment. Maltreatment can be by means of words or deeds. Words, minura-mura mo yung tatay mo sa harap ng maraming tao. Okay? That's maltreatment. You can be validly disinherited. If a child of descendant accuses the testator of a crime for which the law prescribes imprisonment for 6 years or more, if the accusation has been found to be groundless. If you testify in a criminal case against your father, and your father is subsequently acquitted by the court because of reasonable doubt, can you be validly disinherited? I do not think so. Because acquittal based on reasonable doubt means that the accusation is not entirely groundless. Okay. One of the grounds is when a child or descendant is convicted of adultery or concubinage with the spouse of the testator. Masyado namang karimari-marim ito. Okay? Not necessarily. Okay? You are, let's say, 26 years old. Your father, who is a widower, marries a sweet young thing of 21. Tinalo mo yung stepmother mo. You're convicted. Patay ka. Covered. So it does not necessarily involve incest. If a child or descendant, without justifiable cause, refuses to support the parent or ascendant who disinherits him, leading a dishonorable or disgraceful life. The thing I want you to remember in connection with that is that this requires the element of habituality, continuity. A child or descendant cannot be disinherited upon this ground, that he is leading a dishonorable or disgraceful life, upon the testimony of a single act. A father comes home rather early, unexpectedly one afternoon, and he gets the shock of his life. He finds his favorite daughter having the time of her life in her own bed with the family driver, who is a married man. Okay? There is no basis for disinheriting that daughter. Okay? Doon lang naman niya na single act yan. Ibang usapan na if the daughter actually cohabits with that married man. She is already leading a dishonorable or disgraceful life. Okay? Next point. Mere conviction of an offense which carries with it civil interdiction provides a sufficient basis for disinheriting a child. The offense need not be committed against the testator or any close family member. It may have been committed against a total stranger. What's the reason for this? Because, you know, civil interdiction is merely an accessory penalty, which is attached, as far as I remember my criminal law, only to afflictive penalties. When you're convicted of an offense which carries with it the penalty of civil interdiction, that means you must have done something terribly wrong. Mabigat ang nagawa mong kasalanan. And having committed a very serious offense, there is deemed to be a very wide moral chasm which separates you from your parent. That's the reason why this is included as one of the grounds. When a child or descendant by fraud, violence, intimidation, or undue influence causes the testator to make a will or to change one already made, that's another ground for disinheriting a child or descendant. With respect to the grounds for disinheriting a parent or ascendant, number 1 says, when the parents have abandoned their children or induced their daughters to lead a corrupt or immoral life or have attempted against their virtue. with respect to abandonment that applies to both male and female members of the family. The second part, inducement to live a corrupt or immoral life or attempt against their virtue, that covers only the female members of the family, daughters, granddaughters. Okay. A mere attempt by one parent against the life of the other gives the children and descendants the right to disinherit the parent. Your father tried to kill your mother. Sinangkal. Talagang gustong patayin. That is sufficient. You can disinherit your father. Unless, of course, there has been a reconciliation between the two of them. Kasi nga, you cannot be more popish than the Pope. Kung yung nanay mo, pinatawad na yung tatay mo, eh sino ka ba naman, anak ka lang? So, kung nagpatawaran na sila, there is already a reconciliation between the two, you can no longer disinherit your father. Okay. If, however, after your father tried to kill your mother, he was prosecuted and convicted by final judgment, I submit, despite the reconciliation between your parents, you can still disinherit your father. Not on the basis of number 8 of Article 920, but on the basis of number 2. When the parent or ascendant has been convicted of an attempt against the life of the testator, his or her spouse, ascendants or descendants. Okay? Unless, of course, there has been a reconciliation between your father and yourself. Because then, the general rules on reconciliation under Article 922 would apply. What is the effect of reconciliation under Article 922? Reconciliation will deprive the offended party of the right to disinherit, and it will also render ineffective any disinheritance previously made. Okay. When is the reconciliation? Reconciliation is much more than mere pardon. A lot of people on their deathbeds would generally extend an absolute general pardon to all the people who may have offended them, which is quite natural for individuals who realize that death is very close at hand. That is not reconciliation. Reconciliation is more than mere pardon. Reconciliation means that the pardon is extended to the offender and the offender accepts the pardon. And there is a restoration of the former relations between the parties. That is reconciliation. Remember that one of the grounds for disinheriting a spouse is if a spouse has given cause for legal separation. It used to be under the Civil Code that legal separation can only be brought for adultery on the part of the wife, concubinage on the part of the husband as defined in the Civil Code, attempt by one spouse against the life of the other. Now, under the Family Code, Article 55, sangkatutak ang grounds for legal separation. Okay? Even mere alcoholism is a ground for legal separation. Maraming pwedeng madisinherit dito. Okay? Mga mahilig uminom. Okay? Repeated physical violence or even grossly abusive conduct. Mahilig ka makipag-inuman sa barkada mo, sa bahay ninyo, tapos paglasing ka na, tatawag-tawagin mo yung kasama, "Oy, tabachoy, hili ka mga, pulutan dito." Eh, pagpaulit-ulit yan, grossly abusive conduct na yan. Okay? Pwede kang ma-disinherit. You have given cause for legal separation. O medyo tensyonado ka at nagre-review ka sa bar. Pag umuwi ka sa hapon, binoboljag mo yung asawa mo. That's your way of relaxing. Ground for legal separation. You would have given cause for disinheritance. Okay? All right. So, medyo pasadahan lang natin yung mga grounds for legal separation. Okay. Wala namang komplikado dyan. Alright. I call your attention to Article 923. Under this provision, if a person is disinherited, but he happens to have children and descendants, his children and descendants will be able to get at least the legitim. They will be able to inherit the legitim at least. What is the reason for this? The law here is just being fair and equitable and compassionate even to the children of a validly disinherited heir. Isip-isipin ninyo. If your grandfather validly disinherits your father, yung tatay mo was validly disinherited by your grandfather, ang ibig sabihin nun, your father must have done something terribly wrong. Because itong mga grounds for disinheriting a child or descendant, mabibigat yan. Might conviction of an attempt against the life of the testator, or conviction of adultery or concubinage with the spouse. Mabibigat. Maltreatment, especially in the light of Filipino culture or even Asian culture, maltreatment. That's one of our good qualities as Filipinos and as Asians. We have such great respect. We show great respect for our parents and elders. So if you maltreat your parent or descendant, talagang medyo dispalinghado ang takbo ng utak mo. If your father is validly disinherited, ibig sabihin, you are very unfortunate. Napakamalas mo na nagkameron ka ng ganong klaseng tatay. If the law will not even allow you to inherit, not even the legitim, ay sobra naman yan. That's double jeopardy. Diba? Sobrang parusa yun. As it is, you are already very unfortunate in having that kind of a parent. So the law allows you. Pwede ka, you can get the legitim which your father would have inherited if he had not been validly disinherited. Last point with respect to disinheritance. The question is usually asked, if an heir, if a compulsory heir is validly disinherited, what does he inherit? The usual answer is, he gets his legitim. Tama. An imperfectly disinherited heir is entitled at least to his legitim. But there may be situations when he will get something more than his legitim. When would that be? If the testator did not validly dispose of his free portion. In that case, the imperfectly disinherited heir will get not just his legitim, but his entire intestate share. Let's assume that X has 4 legitimate children, A, B, C, D. Okay. He says in his will, I disinherit my son D. Period. He does not say why. Basta, I am disinheriting him. So, imperfect yan. Imperfect disinheritance. And then he says, I institute as my sole and universal heirs my children A and B. C is not mentioned. He is obviously preterited. He leaves an estate of 120,000 pesos. How do we distribute? In this case, D will not just get his legitim. D will share together with A, B, and C by way of intestacy to the 120,000. Each one of them will get 30,000 pesos. Okay. Let us assume that the testator this time says, I disinherit my son D. He does not specify the cause. I give my entire estate to my children A, B, and C. Okay. No preterition. This is where they would be limited to his legitim. 120, one half of that is the legitim of A, B, C, and D. 60,000. So each one is entitled to a legitim of 15,000. The other 60,000 is the free portion, which under the will of X will go to A, B, and C only. So, plus 20, 20, 20, A, B, and C will each get 35,000, while D will only get 15,000. Okay. Supposing that D is validly disinherited. He does not get anything if he is validly disinherited. Wala siyang matatanggap. Everything would go to A, B, and C. But supposing D has two children, E and F, and he is validly disinherited, the legitim of 15,000 will go to E and F under Article 923. Okay? Let's now talk about legacies and devises. Number 1. Can the testator give by way of a valid legacy or device something which he does not own? Pwede bang mamigay ka by way of legacy or device ng property na hindi naman ikaw may-ari? Can there be a valid legacy or device? Yes, as long as the testator knows that he is not the owner. Because if the testator gives out by way of legacy or device something which he erroneously thought he owned, hindi naman pala siya may-ari, the legacy or device is void. Okay? Unless he subsequently acquires the thing by whatever title. Okay. I give you by way of legacy, sabi ko, I give you, my friend, yung pangalan mo, by way of legacy, my house and lot. My house and lot at 123 Espana Street, Manila. Kala ko sa akin, hindi pala sa akin. Is there a valid device? There is no valid device. But 2 years after the execution of the will, I bought that house and lot from the owner. So that when I died, I was the owner of that house and lot. Is there a valid device? Yes. My subsequent acquisition has cured the defect. All right. The testator cannot also give by way of a legacy or device something which already belongs to the legatee or devisee. I give Mr. X by way of legacy the car with plate number ABC 123. When I made my will, he was already the owner of that car. There is no valid legacy. Would it make any difference if after I executed my will, wherein I gave that car to its owner, Mr. X, he sold the car to a third person? The answer is no. The legacy remains void, even if the legatee or devisee subsequently alienates the thing. Unless, of course, in that situation, the legatee or devisee alienates the thing in favor of the testator himself. The subsequent acquisition of the testator should be considered as a clear indication of his intention to validate the legacy or device. Supposing that I give you by way of device the house and lot located at 123 Espana Street, Manila, which I knew was owned by Mr. O. Alam ko, hindi ako may-ari. Alam ko may-ari si Mr. O. Okay? I gave it to you. I said, I'm giving you, by way of device, the house and lot at 123 Espana Street, Manila, which is presently owned by Mr. O. Is there a valid device? The answer is yes. There is an implicit order for my estate to acquire it from Mr. O, so that it can be given to you. Eh, paano kung ayaw namang ibenta nung owner, Mr. O? You just be given, of course, the value of the property. Okay. I say in my will, although I am the owner of only one half although one-half interest lang ang pag-aari ko, although I own only one-half of the house and lot at 123 Espana Street, Manila, the other half belonging to Mr. O, I give the entire property to my friend Mr. F. Okay. Is there a valid devise in that case? Yes. Does the devise cover the entire property? Yes. With respect to the one-half already belonging to me, walang problema. With respect to the one-half still belonging to Mr. O, there is an implied order to acquire that one-half so that it can also be given to you. Supposing that before my death, the co-ownership is terminated. And in the agreement which I entered into with Mr. O, the other co-owner, we agreed that the entire property will belong to him. So I was just paid the value of my one-half interest. Okay. When I died, the entire property already belonged to Mr. O. Is there still a valid devise in favor of the devisee? The answer is yes. There is still a valid devise with respect to the one-half originally belonging to Mr. O, the other co-owner. With respect to the one-half which previously belonged to me, there is no longer a valid devise because there has been revocation by alienation when I agreed that the entire property will be given to Mr. O, my co-owner. I gave you in my will, by way of devise, the house and lot located at 123 Espana Street, Manila, which I knew is currently owned by Mr. O. You did not know that I had that provision in my will. And you bought that property from Mr. O, binili nyo, 2 years after the execution of my will. So that when I died, you were already the owner of the property. Would you have any rights under the circumstances? Yes. Since you bought the property, you are entitled to reimbursement of the price you paid for the property. If, however, Mr. O simply donated that property to you, you have no right to claim any reimbursement because your acquisition would have been by gratuitous title. Okay. Next point. If the property given is pledged or mortgaged to secure a recoverable debt, regardless of when the pledge or mortgage was constituted, whether it was constituted before or after the execution of the will, the rule is the same. The estate is obliged to pay the debt and to free the property from that pledge or mortgage. Although Article 934 mentions only pledge or mortgage, the same rule should apply in the case of antichrisis, okay, where the security given for a loan is, well, the real property is delivered to the creditor. The creditor is allowed to gather the fruits of that property with the obligation to apply the fruits to the payment of principal and interest pursuant to a written agreement. Pwede rin yan. Any other charge on the property will go with it. So if there are easements existing on the property, not covered by Article 934. No obligation on the part of the estate to work for the extinguishment of the easement. Hindi kasali yan. This Article 934 covers only those encumbrances which are constituted on the property to secure a recoverable debt. Okay. Next point. In case of a legacy of a credit or condonation of a debt, remember the rule. These legacies are rendered ineffective. They become ineffective the moment the testator brings an action for the recovery of the debt. Halimbawa, Mr. D owes me 1 million. May utang si D sa akin 1 million. In my will, I say, I give my friend F, by way of legacy, my credit of 1 million against Mr. D. That's a legacy of a credit. If prior to my death, I bring an action against Mr. D for collection, nag-file ako ng case, the legacy of a credit in that case is rendered ineffective. But there must have been an actual case filed. Hindi pwedeng demand letter lang. Alright. Legacy of condonation of a debt. May utang si Mr. D sa akin na 1 million. I say in my will, I hereby give D, by way of legacy, the condonation of his debt of 1 million. Legacy of condonation. If I bring an action against him, that is also rendered ineffective. If the testator is a debtor, yung testator ang may utang, and he gives a legacy to his creditor, the creditor will be entitled to collect not just his credit, but additionally the legacy. I owe you 40,000. In my will, I say, I'm giving you by way of legacy 30,000. How much all in all can you collect from my estate? 70. Okay? You can collect your credit of 40. You can also collect additionally the legacy of 30,000. Supposing that I said in my will, I order that the legacy of 30,000 be applied to your credit. Okay. How much can you collect all in all? 40,000. Okay, 40,000. That's the amount of your credit. So even if you're able to collect 30,000 by way of legacy and you apply it to your credit, meron pang sobrang 10,000. So all in all, you can collect 40,000. You distinguish between the rules applicable to a legacy of generic personal property and a device of generic real property. If the testator gives by way of legacy generic personal property, and after his death, it is discovered that the estate did not own any property of that kind, there is still a valid legacy. Testator says, I give my friend F by way of legacy a car. After the death of the testator, wala na pala siyang pag-aaring kotse. Is there a valid legacy? Yes. The estate will simply acquire a car and give it to F. In the case of a device of generic real property, if there is no property of that kind in the estate, the device is void. If the testator says, I give my friend F by way of device 10 hectares of rice land. Palayan, rice land. After the death of the testator, it is discovered that while he owned hundreds of hectares of sugar land and coconut land, he did not own a single square meter of rice land. The device is void. Okay? The device is void. Applying the provisions of Article 941 of the Civil Code. Remember the rule for legacies for support, legacies for education. A legacy for education lasts even beyond the age of majority until the legatee is able to finish some professional or other course, provided he pursues his studies diligently. Okay? Nagsusunog ng kilay, sabi nga. A legacy for support lasts during the entire lifetime of the legatee. Buong buhay yan. When does a legatee or a devicee acquire a right? With respect to pure and simple legacies and devices, the legatee or devicee acquires a right to these pure and simple legacies and devices from the moment of death of the testator. What about the ownership as distinguished from the right? When does the legatee or devicee acquire ownership of the thing? Again, if the legacy or device is pure, simple, and the thing given by way of legacy or device belongs to the testator, then ownership should be considered acquired also from the moment of death of the testator. Yan ang ibig ko sabihin, nung sinabi ko sa inyo at the start, the most important provision in succession is 777. The ultimate basis of these rules is Article 777. In Article 911, which we discussed just a while ago, sabi ko, if the free portion is not sufficient to cover all the legacies and devices, what is the order of preference? Simple lang. Two-step process. Number one, preferential legacies and devices. Number two, all others pro rata. 911 yan. In Article 950 of the Civil Code, we come across another order of preference. Mas mahaba dito. What's the order of preference? Remuneratory legacies and devices. Next, preferential legacies and devices. Next, legacies for support. Next, legacies for education. Okay? Next, legacies of specific and determinate things, legacies and devices of specific and determinate things which form part of the estate. And finally, all others pro rata. Ang tanong is, when do you apply the order of preference in 950 and when do you apply the order of preference, which is much simpler under Article 911? The answer is very simple. You apply 950 only when the conflict is exclusively among the legacies and devices. In other words, when there are no legitimes to be protected, there are no donations inter vivos. Puro ang conflict ay sa legacies and devices lang. That's the only time you apply 950. Otherwise, if there are legitimes to be protected, if there are donations inter vivos, you apply 911. By the way, when is a legacy or device considered remuneratory? Okay? Para ding yung sa concept sa donation, yung remuneratory donation. If it is intended to recompense previous services which do not constitute demandable debts. O, pinamanahan mo yung kaklase mo na laging nagdidikta sa iyo pag nagre-reside ka sa College of Law. Remuneratory yan. Okay? Yung kapitbahay mong doktor na palagi mong chinechempo na sa umaga, Dok, ano ba maganda sa sipon? Ubo, may sipon ubo yung anak ko. Ay, doktor naman, kapitbahay, reseta, walang bayad, libre, gratis. That's, if you give him something by way of your will, that would be remuneratory in character. Next point, 957. The article gives us three situations or causes which would render the legacy or device ineffective. What are these? Transformation, alienation, loss. Okay. When is there transformation? If the thing given by way of legacy or device is changed in such a way that it does not retain its form or denomination. What is meant by form? The physical appearance. What is meant by denomination? The name by which the thing is called. Okay. If this table has been given to you, this particular table has been given to you by way of legacy. But before the testator's death, ginawa ng testator, ginamit yung kahoy nito. This was made into a chair. That is transformation. There is a change in the physical appearance and in the denomination. In the form and denomination. Iba na ang itsura. Siyempre, iba itsura ng upuan, ng chair, from a table. Okay? And the denomination has also been changed. Ang tawag hindi na table, chair na. Testator gave you, by way of devise, his farm in Bulacan. Before his death, he converted that farm into a beautiful resort. He constructed cottages, swimming pools, etc. Dati, puro palayan yun. Transformation. The device has been rendered ineffective. Wala na. You were given by way of legacy a very beautiful ring with a diamond. Before the death of the testator, he had that ring converted into a necklace. Okay? Or a pendant. Wala na yun. The legacy has been rendered ineffective through transformation. Okay? Second cause for rendering ineffective a legacy or device is in case of alienation. If the testator gives you something in his will, and then he later on sells, alienates the thing, wala na. The legacy or device in your favor is rendered ineffective. Unless, of course, the alienation is temporary in character. It was sold with the right to repurchase. And he, in fact, repurchases it. All right. The only question you ask when it comes to alienation is this. Did the testator intend to permanently part with the ownership of the thing? If the answer is yes, forget about the legacy or device. It has been rendered ineffective. Third, loss. If the loss took place during the lifetime of the testator, regardless of the cause of the loss. If you were given by the testator in his will, by way of legacy, a very beautiful grand piano. And then, before his death, minsan mainit ang ulo niya, ibinalibag niya yung piano. Wasak ang piano. O sinunog niya yung piano. Wala. Regardless of the cause of the loss. As long as the loss took place during the lifetime of the testator. That will render the bequest in your favor ineffective. If the loss occurred after the death of the testator, you distinguish. If the loss happened because of a caso fortuito without the fault of the heirs, that also renders ineffective the bequest in your favor. But if the loss happened because of the fault of any of the heirs, you can still recover the value of the property. As a matter of fact, that is one of those instances under the law where the law imposes solidarity. If several heirs take possession of the hereditary estate after the death of the testator, they are solidarily liable for any loss. So kahit na isa lang sa kanila may kasalanan, solidarily liable. Lahat ng heirs who took possession of the hereditary property after the death of the testator. Last point on legacies and devises, 959. Okay. A disposition made in general terms in favor of the testator's relatives shall be understood to be in favor of those nearest in degree. Isa lang rule ang applicable under Article 959. The rule of proximity. Rule of proximity. The other rules of succession do not apply. You don't apply the rule of preference between lines. You don't apply the rule of representation. Walang representation dyan. Plain and simple. Proximity. You simply count the number of degrees. Whoever are the nearest relatives in terms of degrees, kaya nasa direct line niya o nasa collateral line, kung sinong mas malapit, siya ang magmamana. Okay? You be a little bit careful, however, in applying Article 959. If the testator says in his will, I give my house and lot in Quezon City to those who are entitled thereto, You don't apply 959 in that case. What do you apply? You give it to those legally entitled thereto under intestate succession. Ha? Pero kung sinabi niya, I give that property to my relatives, 959 would be applicable. Sometimes, a lot would depend upon the phraseology. Okay. So, alimbawa, sabi ng testator, I give that property to my relatives. Ang mga relatives niya are the following. Patay na yung tatay niya, grandfather, is still alive. His uncle, the brother of his father, is alive. His two brothers, A and B, are alive. His third brother, C, is dead, but is survived by a son. And he is survived by his wife. I give my house and lot in Quezon City to my relatives. 959 is applicable. So, sino magmamana nun? Applying 959, that disposition is understood to be in favor of those nearest in degree. So, you simply count the number of degrees. GF, 2 degrees. A and B, 1, 2. 2 degrees din yan. Okay? U, 3 degrees. D, 3 degrees. So, sino magmamana? GF, A, and B. What about D? Hindi po pwedeng i-represent niya. Walang representation under Article 959. Simply count the number of degrees. You will notice that we don't apply here the rule of preference between lines. Ordinarily, succession, direct ascending line is preferred over the collateral line. But those rules are not applicable. Isa lang ang rule na applicable under Article 959. It is the rule of proximity. Okay. Which is one of the most important rules in intestate succession.